meeting of the Committee on Land and Physical Infrastructure, and to welcome all present and to welcome the viewing and listening public to this first public hearing regarding the 2023 NIDCO report inquiry. I'd like to advise that the meeting is being broadcast live on Parliament's Channel 11 and Radio 105.5 FM and the Parliament's YouTube channel, ParlView. First of all, let me introduce myself. I'm the chairman of this Joint Select Committee on Land and Physical Infrastructure. My name is Deruk Timal, and I'd like to invite members of the committee to introduce themselves.
Good morning, Mr. Morris Julian, Vice Chairman.
Good morning, Simon de Nobrega, member.
Good morning, Dr. Ibrahim, member.
Good morning, Renuka Sagram Singh Suklal, member.
Okay, thank you, members. Our inquiry topic today is to commence the committee's first public hearing pursuant to the inquiry into the 2023 NIDCO report on the Sir Solomon Hochoy Highway extension to Point Fortin from 2010 to 2023. But today we have officials from the Ministry of Works and Transport and the National Infrastructure Development Company Limited on NIDCO. Just for the benefit of everyone and our viewing public, just to summarize the objectives of the inquiry, there are 5 major objectives. First, to examine the efficacy of the procurement policies and procedures used to implement the project. Second, to determine whether due diligence governed the execution of all aspects of the project. 3, to assess the challenges faced in relation to the oversight mechanisms for the financial arrangements used to fund the project. 4, to assess the measures taken to ensure value for money in the contract with OAS. And 5, to examine the reasons for making amendments or addendum to the original contract with OAS. So those are our 5 major inquiry objectives. And I'd like at this point to ask our entities to introduce themselves, following which I'll ask for brief opening remarks from the chief officials present, and that is the Permanent Secretary, Ministry of Works and Transport first, and then the chairman of NIDCO. So we go into our introduction of the officials who are here present.
Good morning, Chairman and members. My name is Sonia Francis Yearwood, Permanent Secretary, Ministry of Works and Transport.
Good morning, Chairman and members. I am Anil Mohan Singh, Acting Director of Highways, Ministry of Works and Transport.
Good morning, Chairman and members. I'm Herbert George, the Chairman of NIDCO.
Good morning, Chairman and members. I'm Esther Farmer, President, NIDCO.
Morning, Chairman and members. I am Ravi Sriram, Manager of Finance and Corporate Planning, NIDCO.
Good morning, Chairman and members. Janice Haritran, Manager of Engineering and Programs, NIDCO.
Good morning, Chairman. My name is Navin Ramsingh, Road Sector Specialist, Ministry of Works and Transport.
Hi, morning, everyone. My name is Mahadev Jagdev, Program Director, Ministry of Works and Transport.
Good morning, Chairman and members. My name is Petal Alexander. I am the Director of the Legal Services, Ministry of Works and Transport.
Okay, thank you very much. So we go for the brief opening remarks. So, Mrs. Yearwood, we start with you.
Thank you. Once again, good morning, Chairman and members of the committee, colleagues from the National Infrastructure Development Company Limited, and the viewing public. The Ministry of Works and Transport, in accordance with Theme 3, Improving Productivity Through Quality Infrastructure and Transportation of the National Development Strategy for Trinidad and Tobago, is cognizant of its mandate for the provision of efficient and effective national transport infrastructure. In so doing, the Ministry and its respective state entities' overall program of works reflects this aspect in the provision of efficient and effective national transport. In 2008, approval was granted to the Ministry of Works and Transport to pursue an overall highway development master plan, which sought to undertake construction of new highways projects throughout Trinidad and in 3 phases. At this time, approval was also granted to utilize the National Infrastructure Development Company for procurement and project management services for the construction of Phase 1. One of the identified projects under this program was the construction of the Sir Solomon Hochoy Highway to Point Fortin. In 2008, these works entailed the construction of a 4-lane divided highway to international freeway standards and comprised of several segments. Over the years, both the Ministry and NIDCO continue to collaborate in seeking to achieve this mandate. The Sir Solomon Hochoy Highway Extension Project was officially opened in October 2023 and is now referenced as the Archibald de Leon San Fernando Highway. To this end, my team and I stand ready to answer questions to the best of our collective knowledge and expertise. Thank you.
Okay, thank you very much, Mrs. Yearwood. Mr. George?
Thank you, Mr. Chairman, and good morning to you, committee members, viewing public, team from the Ministry of Works, and to my colleagues from NIDCO. Firstly, I wish to thank you, Mr. Chairman, and your committee for varying your schedule to facilitate our attendance today, either when we requested additional time to submit our written responses to questions, and also to facilitate my attendance to a previously scheduled personal engagement abroad that clashed with your original schedule. Today we stand ready before you and your committee to give every assistance possible by providing accurate and reliable information on what undoubtedly has been the most significant infrastructural road construction project that our country has undertaken. We admit that we are operating at a slight disadvantage. For whereas NIDCO has been a prime agent in the execution of the project, the managers who were present during the initial stages of the project are no longer present at NIDCO to testify before your committee. The team today all joined the project at a much later phase in 2015, except for Mr. Dennis Haricharan, who joined a few years earlier. But even so, Mr. Haricharan was not a senior manager at the time. We have, however, perused the project records and gotten from there relevant information to provide our answers to questions that have been and would be posed to us. We are committed to providing the facts and to restraining ourselves from regaling you with opinions formed during our perusal of the project information. We now place ourselves at the complete disposal of the committee to orally answer its questions and to provide it with additional written information if requested. Thank you, Mr. Chairman.
Thank you very much, Mr. George. Just to remind everyone that our hearing today is divided into 2 sessions. Of course, we are in the first session. We will be going up We'll be going up to 12:30. There'll be a break for lunch. We'll resume at 1:30, and then we'll be going up to 3:30. So that's our schedule for today. And before we start the questioning by the committee, I'd just like to remind both committee members and officials, in order to maintain organized approach to our hearing today, that if you can direct your questions and concerns through the chair. A reminder that microphones should remain muted until recognized by the chair. And we now proceed to our discussions. First of all, I would lead off by one or two general observations, general comments. The first one is that I noticed that NIDCO chose to label its report, its 2023 report. The title that they gave was the Saga of the Susurman Hochoy Highway Extension to Point Fortin project from 2010 to 2023, an account of the development and execution of the largest infrastructure development project implemented in Trinidad and Tobago. And Mr. George, I was just wondering about your choice of the word saga in the context of the report that you have presented. Would you care to share your thoughts on that with the committee?
Thank you, Mr. Chairman. When I looked at it, I thought the history was quite colorful. Here you had a project that was, as I said, undoubtedly the largest project, road building project in the country. It started with much expectation. Before long, it ran into difficulties, lots of protest action that delayed execution. Then there was this international company engaged in the execution of the project that appeared to have been carefully chosen, and one that ran into difficulties, financial difficulties, what we will probably call bankruptcy. So that company had to be removed. But prior to that, there were two addenda, Addendum 1 and 2, that varied the execution or the proceedings. And the company, that large company with so much promise, was there seeking to be extricated from the project. We were almost facilitating it. So they were arguing, well, we have difficulties, so we want the project to be scaled back. And they wanted to be allowed to do parts of the project that they felt comfortable or able to do at the time, having regards to the financial difficulty. And at one time they were talking about, just tying up things, closing up and going back home. And we almost were saying, well, facilitating that, because we were talking about their contracting with local contractors. And after having done so, they will novate the contracts to the employer, who will then take on board those contracts and carry out the completion. So I felt it was very colorful. And it was not even a case where, even if that was so and they had lost the ability and will to continue with the project, we could have given them permission to subcontract to local contractors, but they should have been left
in the fray. Because you see, it was a design build contract. They had a risk. They had the design risk. They had the construction risk. So, I felt those occurrences, as I said, were quite colorful. And that is why we use that word, the saga of the project.
Okay, thank you for your detailed response. It's just that, in terms of cultural connotations, when the term saga, especially when it's combined with saga boy, there are certain cultural connotations that arise. And I just felt the start of the discussion, I felt it's interesting as to why NIDCO would choose to title the report a saga. So thank you for that response. And I'd just like to get directly into your responses. And this would also impact on the Ministry of Works and Transport in terms of the question of the employer. Under the contractual arrangements, specifically the extension of the Hochoy Highway to Point Fortin, that particular phase of the National Network of Highways project, the contractual arrangements that were entered into utilizing the design build model and the general conditions of contract being what is referred to as the Yellow Book, which is the design build conditions of contract for mechanical plant and equipment and also construction projects. So the employer within that contract, within the contract, guided by the general conditions of contract, the Yellow Book, FIDIC, was NIDCO. And in response to, under Objective 1, Question 4, on page 2 of 36 of your response, the committee, we did ask a question as to clarification in terms of the term employer, because at some points in time in the report, we realized it was being used interchangeably with the Ministry of Works and Transport. Now, I think in your response that you have clarified that with regards to the project that we are specifically speaking about, NIDCO was the employer, and there were two instances within your report, which is on page 1. You have indicated that the employer was the Ministry of Works and Transport on behalf of the government of the Republic of Trinidad and Tobago. And this is in regards to the feasibility study that was contracted to Lee Trintoplan, the joint venture of Lee and Trintoplan. And in that case, the employer was the Ministry of Works and Transport. And also on page 16 of your report, you have indicated that where you indicated the term employer was used, you also said that the Ministry of Works and Transport on behalf of the government of the Republic of Trinidad and Tobago, and this was concerning additional payment based on contract Addendum 1. So are you with me? Yeah. So my question is, how come in the case of the additional payment based on contract Addendum 1, the employer shifts to the Ministry of Works and Transport on behalf of the government of the Republic of Trinidad and Tobago?
identify, the first reference of the Ministry of Works acting as the employer on behalf of the government of Trinidad and Tobago in respect of the employment of Lee Trinidad, that is correct.
Yeah, that's
right.
okay. That's straightforward.
Right. When we go over to the second occurrence where that was used, it was in reference to the indicative design. That indicative design was designed by Lee Trinidad. So the employer there we use the Ministry of Works again because it was one of their contractors, or yes, one of their consultants who was responsible for the indicative design. Afterwards, when it was tossed over to NIDCO, everything else, when where employer is implied, it is NIDCO acting on behalf of. So those two occurrences, I trust that I have clarified the maybe confusion created.
Yeah. All right, I'm okay with that. Mrs. Yewood, you have anything to add there? Oh.
No, Chairman. I think the Chairman of NIDCO has identified the areas.
Okay. Okay, thank you. So now we're clear about NIDCO as the employer in accordance with the contract conditions. But what I want to ask is in terms of the relationship between NIDCO and the government of Trinidad and Tobago and the role of the Ministry of Works and Transport for this particular contract, was there an agreement between NIDCO and the government of the Republic of Trinidad and Tobago or the Ministry of Works and Transport in which NIDCO was contracted to provide services to the Ministry of Works and Transport?
Chairman, I defer to the Permanent Secretary. She will speak to the Cabinet note that enabled that to take place.
Okay. Thank you, Chair. As identified in my opening remarks, we would have gotten our mandate to move ahead with NIDCO as the procurement agency and the project management agency via cabinet decision. If I'm understanding your question, though, I think you're asking even further than that, if we entered into a contract with NIDCO. We did not enter into a contract with NIDCO. What we entered into with NIDCO was a letter of intent and an MOU, which more or less places the framework within which NIDCO would undertake projects on our behalf. The ministry is also guided by Circular Number 12 in terms of the utilization of state entities when utilizing a specific entity for a project that will utilize state funds under the IDF fund, which is where this initiated.
Okay, the reason I'm asking as well is that, under FIDIC as well, sometimes the arrangement is that the procuring agency, acting on behalf of, say, the government, is assigned the term employer's representative in some situations that I've seen in the past. And in this situation here, NIDCO is actually placed as the employer, and not the employer's representative. So it's just that I'm just trying to get it clear, and for the benefit of the committee members and the viewing public, as to the definitive role of NIDCO being the employer and not the government of Trinidad and Tobago, or the government of Trinidad and Tobago via the Ministry of Works and Transport, and not the employer's representative. Any thoughts on that?
Mr. Chairman, all I can say is that, well, in this in this situation, yes, NIDCO is treated or is assigned the role as employer. This is not to say that NIDCO will go off on its own and just do this thing as though they had total and absolute authority. NIDCO, realizing the need to work in conjunction with the line ministry, in which case NIDCO would have, taken on the role as the employer, but NIDCO will seek from time to time guidance, maybe, flight instructions, maybe, from the line ministry, who still has a role and a position to maybe oversee what is being done, and even things as making payments to contractors. We will, NIDCO that is, will issue the IPCs. And the IPC is a fairly legal document. Once it's issued, payments must be made to the contractor. But that IPC would go to the ministry for payment. The ministry will disburse the payment to NIDCO, and then NIDCO will make payment to the contractor. So there is still a very active interface between NIDCO and the line ministry, in which case the Ministry of Works. So we work in conjunction with the line ministry, but legally we are the employer, in the sense that we will sign the contract. We will be the line ministry, for example, would not go directly and instruct the contractor. They will do it through NIDCO.
Yeah.
All right? So that's how it worked, Chairman.
All right, and the document guiding that understanding was a memorandum of understanding that.
Yes, Chairman. As I indicated, we have two documents that guide that understanding. The broad document of Circular Number 12 in terms of how we are allowed to manage IDEA funds, and then a more specific MOU, which sort of sets a framework for the interaction between the ministry and NIDCO on specific projects.
All right, so under such an agreement, the NIDCO is accountable to whom?
NIDCO is accountable to the Ministry of Works and Transport, and by extension, the Government of Trinidad and Tobago as a state entity under the Government of Trinidad and Tobago.
Okay. Okay, thank you.
Of course, through the board. My apologies.
Okay. Okay, in terms of the coming back to the question of NIDCO being the employer, and then was NIDCO, how did you get your money? Were you paid for your service by the Government of Trinidad and Tobago? Was there an understanding, and there was a fee structure, or payment structure that there was in place, that NIDCO would be paid or reimbursed for its expenses?
Mr. Chairman, yes, there is a prearranged or agreed management fee structure or fees that are paid to NIDCO for its services. So before a contract starts, there will probably be there will be an agreement through the line, with the line ministry, to pay X% of the contract sum to NIDCO for its management fees, and that goes to Cabinet as well. So Cabinet approves, and the line ministry conveys the information and guides the execution of the project or the disbursement of funds to NIDCO as the project progresses. So yes, there is an agreement.
Okay, thank you. But within this particular contract, there were sums, I think there were provisional sums that were allocated for what is termed management fees and also for construction supervision. Were any within were NIDCO charges part of the contract sum, the budget, or was that separate to the contractual arrangement?
Mr. Chairman, it is part of the budget, and I'll defer to the President, who will give us some more information on that.
When NIDCO is awarded a project by the ministry, the cabinet approves a budget. The budget has the, in this case, the construction sum for the contractor. It will have a budgeted fee for NIDCO. It would also include stuff like utilities, relocation, various items that would be part of a predefined and pre-approved budget. So while NIDCO fees will not form part of the contract sum with OAS, it will form part of the budgeted sum approved by the ministry.
Okay, so like, I mean, a certain figure has been given as to the cost of the project. The OAS contract in particular, I can't recall the exact figure. But when that figure is given, that excludes payments to NIDCO for their services, right?
If we
so the overall cost of the project, if we get a true picture of the overall cost, well, then we'll have to also factor in the payments that were made to NIDCO for their services.
Correct. If you're speaking of the cost of OAS contract, that would be one sum in itself. If you're speaking of the cost of the project, it will include different elements, and that will include NIDCO fees, correct?
Okay. Would it be possible for NIDCO to provide the committee in writing as to, for this particular project, for the contract, as to what were the payments that were received? Yeah. So if that could be provided to the committee, yeah? It's here.
Chairman, may I refer you to page 15 of 36? I gather that it is there as part of the budget, that budget schedule that was given.
Okay, yeah, I see NIDCO management fees 2.5%, 183 million TT dollars.
Yes, Mr. Chairman, that's correct.
Okay, thank you. All right, so just trying to understand the framework, in particular with regards to the term employer in the arrangement with OS. So we can move on from there, and I'll probably hand over to Member Sagram Singh Sukla.
Thank you, Chairman, for the opportunity. Again, pleasant good morning to everyone. Of course, thank you for your time, and of course, for recognizing the importance of this inquiry. Of course, Chairman, you have mentioned, for the benefit of the listening public, this was perhaps, or was, the history would dictate, the largest spent on any infrastructural project in Trinidad and Tobago. Very interestingly, Chairman, in your you would have mentioned that this current group that sits before this JSC is disadvantaged because members who sit here were not necessarily persons who sat when this particular incident would have occurred, this project would have been executed. I noted that particular response, save and except for, I believe, Mr. Harry Charan. But you did indicate that at that point in time, Mr. Harry Charan was not a senior member of management. But notwithstanding, Chair, notwithstanding the fact that this entire ordeal, notwithstanding the fact that you may have been a stranger personally to this ordeal, before this committee, Chairman, and for the benefit of the listening public, there are 3 written submissions that appear before this committee for its consideration. The first would have, of course, been what Chairman would have referred to in his commentary. That report, Chairman would have asked you about the name of the report. That's a report dated the 31st of October 2023. And for the benefit of the listening public, it's a report entitled The Saga of the Sir Solomon Hochoy Highway Extension to Point Fortin Project from 2010 to 2023, an account of the development and execution of the largest infrastructure development project implemented in Trinidad and Tobago. You're familiar with that project, Chair? That report, Chair? That report dated the 31st of October 2023. Also before this committee, Chairman, are written submissions, 2 sets of written submissions. One set of written submissions dated February 19th, 2024. You're also familiar with that submissions. And thirdly, before this committee for its consideration is also written submissions volume 2 dated February 22nd, 2024. And you are familiar as well with that submission. The reason why I'm starting from that place is because you would have indicated, Chair, that this entire saga, and just making reference to the name of the report, many of you would not have been sitting where you currently sit when this incident would have occurred, this project would have been executed. But notwithstanding that, we have 3 documents that are before this committee for its consideration. Now, I want you to be able to identify for us, because we live in a society that is very litigious, one, and evidence in the creation of any report is critical, because evidence is what differentiates fact from fiction. These 3 reports, Chair, could you just elucidate to this committee what information, generally speaking, or what evidence, generally speaking, you would have relied upon in your formulation of these 3 reports, these 3 documents that are currently before this JSC? And I'll tell you why I'm asking this. Because I don't, for the benefit of your committee, we don't want members of the public to speculate that this is a Nancy story. And I, too, as a sitting member of this committee, am very interested in the fact that if you were not here, what evidence you would have relied upon in the creation of these 3 documents.
Mr. Chairman, as I indicated in my opening remarks, we relied on the project record. We perused the project records to generate those reports. I have not been asked, but let me just give you one example. It is a fact that there was an Addendum 1. It is a fact that if you go into the record, you will see the details of what Addendum 1 was all about. So that's the fact.
Right.
But I have a big problem with with Addendum 1. I do understand it.
So just so I understand where you're getting at with respect to the addendum and all that, but just for the record and just so that the committee can be clear, these reports, notwithstanding the fact that the current incarnation, the current persons who sit in NIDCO was not there, you are satisfied as a chairman of NIDCO that there was sufficient evidence before the current committee in order to be able to accurately present these reports that appear before this committee?
Mr. Chairman, my answer will be yes.
And therefore, your current board and administration totally and completely associates itself with the report and the contents of the report that appears before this committee.
Mr. Chairman, we are fully in support of the contents of the report, and that's why, for example, the appendices, they're so voluminous, because every time a statement is made, we will refer to the project record, that talks to the item.
Thank you very much. Now, if I may briefly go to your mission of NIDCO, current mission, it is to fulfill our role as a leading project executing agency. And that is something your board, together with your administration, associates themselves with, correct? NIDCO, through a philosophy of managing our business with the highest ethical standards. That is also a part of NIDCO's mission. This is something that you associate yourself completely with, Mr. Herbert?
Totally, Mr. Chairman.
Another aspect of NIDCO's mission is providing optimal quality and value while acting in a responsible manner with our employees, our stakeholders, our environment. Is that something that your board holds dear to its existence? Is that something that is dear to your board?
Mr. Chairman, we are totally guided by that principle.
And NIDCO's vision is to create a premier management organization with competencies responsive to the delivery of strategic infrastructure projects, always mindful of our stakeholders' best interests and the impact of our work on the environment. And I would imagine that too is also something there to the operations of NIDCO.
Totally, Mr. Chairman.
And notwithstanding the fact that this is a new board, I would imagine this would hold through even 10 years ago, 15 years ago, 20 years ago. The responsibility, of course, of the entity to the public and to the people of Trinidad and Tobago. I want to believe that notwithstanding the change in the board and the faces that appear before us, this ought to have been critical in the operations of NIDCO even 5, 10, 15, 20 years ago. Would you agree with me?
That is quite correct.
Now, thank you. Thank you, Mr. George. So again, we have 3 documents that appear before us. We as members of the committee, Chair through you, would have had the benefit of reading these documents, digesting these documents. But as you will appreciate, these JSCs are conducted not just for the members' benefit, but it's primarily conducted for the benefit of the listening and viewing public. Because at the end of the day, every member here, including your good selves, we have a responsibility to the public and a responsibility in transparently presenting to the public on occurrences and things would have happened, that it falls under our management. So for that very reason, Mr. George, Chairman, I want to ask some specific questions as we historically timestamp this project. Because you would have alluded to the fact that, surrounding me are documents upon documents provided by your good self to this committee, and it may be a lot to digest. And I believe, Chair, of course, through you, it's necessary for us to timestamp this project. Very concise and precise to the benefit of the listening public who would be following. Now, and the questions that I have, the specific questions are questions based on those 3 documents you would have submitted. Your report, submissions volume 1, which as I said before is dated 19th of February 2024, and submissions volume 2, February 22nd, 2024. And if I may respectfully, through you, Chair, begin with the report dated the 31st of October, 2023. Now, and that is also for your benefit, the members of your committee, your entity, Mr. George, so that you all can, follow the line of questioning. Now, in your executive summary, page 1, there is a mention of July 1996, and I know Chairman would have spoken generally about it, but in your report, which we have had the benefit to digest, but unfortunately the members of the public would not have had. I'll start from events from 1996. July 1996, in that report dated, again, 31st of October 2023, mention is made of an agreement with the Inter-American Development Bank to implement the National Highway Plan. Mention is made that the IDB approved procurement process implemented to secure consultants for conducting feasibility study and designs. And that's in your executive summary, page 1 or thereabout. Based on that statement, Chairman, of course, you can defer your questions, as you know, to any member of your team who may be best positioned to answer this. Can you indicate, so in July, so we're starting from July 1996, that loan agreement. Can you elucidate or give a little more information on what happened with that specific loan agreement in July 1996?
Okay, Mr. Chairman, I will start and then I will defer to the PS afterwards. But we spoke about the report mentions the loan agreement, a loan agreement from IDB. Actually, the loan agreement number that one will find in the record will be IDB 932/0C. /0C. So it is on that basis it is categorized as this IDB loan agreement. What was it for? We don't have the all right.
We will have jumped in that because when the procurement went out.
With the leach in the plan, okay.
Right.
All right, Mr. Chairman, if you'll just permit me to just wait as I consult with the ministry's team. Sorry. Okay, Mr. Chairman, could we be permitted to locate the information and make it available either later in the proceedings or after? But we'll try to locate that agreement that spoke to this 1990.
Because I have several questions on that specific loan agreement. So yes, it would be critical for you to, if you can probably put your hands on that. So I can move on from 1996 and certainly flag it as an issue that I would want to interrogate probably later in the proceedings. Well, certainly later in the proceedings. So we again time stamping July to 1996. You have requested some time to put your hands on the document. No problem. We will revert to that. I want to take you now to October 2004. Again, at page 1 of your executive summary for ease of reference. At that juncture in your report, mention is made of a joint venture, Trinto with LEA, Trinto Plan, LA, which is Canadian, and Trinto Plan, which was local, was contracted by the Ministry of Works and Transport to provide consultancy services for undertaking the feasibility study and design for the extension of the highway. This design was produced and used to secure approvals. So that was stated in the report. So I have a few specific questions as it relates to that joint venture. But before we proceed, you have information on that joint venture available, right? Well, let's see how the line of questioning goes. Okay. Was there a signed written agreement between LEA and Trinto Plan in 2004? Would you be able to say if there was a signed written agreement? I'm hearing members of your
maybe the
team.
Ministry of Works and Transport, because they were the ones who procured the services of the Trinto Plan. Yeah, and is there available a copy of the joint venture agreement between Lee and Trinto Plan?
It is not ready. It wasn't asked for, but we'll have to check in our records to see if we could get a copy of the agreement, right? Between the Ministry of Works and the joint venture.
And that member, Mr.
Ramsing.
Ramsing. Okay, and you're familiar, you're familiar, sir, with the contents, though, of that agreement, notwithstanding the fact that you have to get a copy. Are you familiar at all with that specific agreement, the contents of it?
No, I am not.
Okay, so what I would be requesting, Chair, of course, through you, again, we don't have that 2004 report, but I would certainly want, for the benefit of the committee's consideration, if we can have a copy of that agreement. And Chair, through you, if I can request from the Ministry of Works and Transportation together with NIDCO, well, of course, the agreement would speak to what were the terms of the agreement between LEA and Trinto Plan? And of course, Chair, through you, what was the total cost for the services provided by the joint venture? I'm interested in who paid these funds. Chair, through you, I'm also interested in were the funds from the IDB loan? Chair, through you, if I may respectfully request from the members, I would also want to know what was the division of the fees paid to both LEA and Trinto Plan.
Member Sukla, let me just clarify.
Of course,
because Lee Trinto Plan would be a joint venture. So I think the Ministry of Works and Transport, I think we'd have to advise, because maybe there would just be one payment to the joint venture, and then they would have their internal arrangement how that is sorted out.
Yes.
Yeah?
Yeah, of course.
So,
but if we can at least get that information.
Yeah, what payments were made to Lee
What
Trinto
payments were made? Correct. Correct. And to reiterate what Member Ibrahim, Dr. Ibrahim would have indicated, with the funds, the source of funds, was this funds from the IDB loan. And of course, if there are copies of the feasibility studies and design resulting from their deliberations, that too is something that I would want to request, Chair, of course, through you. You have?
Chairman, it is in Appendix 1.
Well, I may have missed that then. So then, so there are copies of the feasibility studies and design resulting from these deliberations. It's in Appendix 1. And did these studies and design include a budget cost? Then, since it's there at Appendix 1, would you be familiar, Ms. Farmer, whether or not these studies and designs included a budget cost?
Mr. Chairman, could we?
defer to. All right. I'll defer to Mr. Ramcharan because he has electronically a copy of that appendix, so he can pull it up on his system and confirm whether that is there. So.
Yeah, sure.
Chairman, through you, I could confirm there's no details provided in the appendix that provide guidance on the overall budget of the works.
So there's no evidence at all as to, just again for the record, so there's no, based on the information that you all have, you're saying that there is no budget document that would have been relied upon.
Chairman, through you, in terms of the information included in the appendices to the committee, there is no information regarding budget. However, at a later date, we can also peruse our records and provide that information.
Okay.
If it's available.
Just for clarification, the lead Trinidad plan feasibility study, the contracting party was, of course, lead Trinidad plan, but it was the Ministry of Works and Transport, right? Not NIDCO.
Yeah.
Right. So I think prior to that, Member Saga Singh Suklal, in terms of you did ask for the schedule of the fees paid. Yeah. So I think that would address.
Agreed, Chair.
Yeah.
Agreed. Now, if we may move to 2009, also from the report. So I'm not in the submissions yet, I'm still in the report. And mention is made that in 2009, so we would have moved from 1996, the loan agreement, which of course you would have requested, NIDCO would have requested for some time to bring before the committee. We moved to 2004, the joint venture. Of course, some information, there are some gaps that I would have, of course, respectfully, through your chair, made a request for some documents. Now, 2009. We come to 2009. In 2009, from the report, you would have indicated, well, NIDCO would have indicated that an international consultant, AECOM, was contracted to provide project management services for the preparation of the tender packages needed to procure contractors. Scopes of work was later expanded to include their services as FIDIC engineer on the highway extension project. And that, inter alia, were some of the statements made by NIDCO in its report, again dated the 31st of October, 2023. Based on that statement, would the entity be in a position to say, was AECOM contracted pursuant to the IDB approved procurement process? So in 2009, AECOM comes into the dance. Would you be able to say if AECOM was contracted pursuant to the IDB approved procurement process in 2009?
Mr. Chairman, it would have been so because NIDCO tender process or procurement process did not vary. It is not varied to suit the project. It is the IDB tender process is fairly maybe international or universal, so we will not do it only when there is an IDB loan involved. We'll continue the process. By that time, the process would have been ingrained in the NIDCO's tender process.
So
Okay.
yes, generally it would have been.
So then, so I hear the submission. So then, for the benefit of the public, then in 2000, and of course for the committee chair through you, can you then indicate very simply how was AECOM contracted then? The terms of reference. How was AECOM contracted?
Okay, so Mr. Chairman, an RFP would be prepared, and it would be issued nationally. Internationally, it will be advertised in the various media, and
so the steps, just simply put the
okay.
steps.
Yes, it will
how
be
was
advertised.
AECOM contracted?
Was it an envelope?
This wasn't advertised. This was selected.
George,
This is selected.
I refer you to your response to question 6 on page 3 of 36.
Yes, thank you,
I
Mr.
think
Chairman. Yes, it's outlined there. So I will just...
If you could just briefly summarize,
Yeah.
or give the gist of what it is.
Okay. So there were 8 selected transport infrastructure consultancy firms. So the RFP would have been sent to those 8 firms, and the 8 firms we are referring to would be AECOM, ARUP, CPCS, WSP, Atkins, Realis, Halco Group Limited. So documents would have been sent out to those 8 firms. So the tender was issued on November 24, 2008. The tender closed on December 5, 2008. After the tender was closed, we had received submission from 4 of those 8 firms: AECOM, ARUP, I'm just shortening it, CPCS, and WSP. The submissions would have been evaluated by an evaluation committee based on criteria that would have been contained in the RFP. And based on the results of the evaluation committee, points were awarded for understanding of the situation, systems and procedures, company/consortium, staffing, finances, and contractual, and to give you 100 points. The evaluation was done, and coming out of that, the results of the evaluation were that AECOM emerged the winner with 77 points. ARUP was second with 72, CPCS third with 66, and WSP fourth with 61. The recommendation was made it was determined that AECOM would be the preferred tender. Thereafter, there would have been a negotiation with AECOM. Usually you do that to clarify scope and to ensure that what you want is what they have tendered for. And subsequently, following the conclusion of the negotiation process, project management contract was entered into with AECOM in May of 2009.
Just for the record, so we understand the procedure. You would have succinctly take us through the procedure. Who would have recommended that AECOM be contracted?
Mr. Chairman, the evaluation process would have been used. You see, so you use this very
detailed
objective criteria. You apply it to the submission,
right?
And you score it, and you use the results to determine.
Thank you very much. Now, so you have taken us to where recommendations are made. You would have indicated that this very objective valuation committee would have made the recommendation. From your recollection, would you be able to say how were they paid and how much AECOM was paid? And of course, I know there are written submissions, but again, it's for the benefit of the public to follow through, follow along with this particular, JSC.
Yeah,
Mr. Chairman, there was a cap fee of US $2.06 million, and that was for phase one of the services to be performed. Payment from those fees would have been done on a rate basis. So they will do the works and submit their rates, and there was this cap of $2.6 million US dollars. The phase two works, there's also a cap fee of US $7.4 million. So that would have been the total contract figure, consisting of those two cap fees, and payments from those fees would have been based on rates and so that was also approved in the contract.
A copy of this contract, it's also in Appendix 1. Good. And again, for the benefit, so the copy is there, but again, for the benefit of the listening public, can you then briefly identify, based on that contract, what were the responsibilities under this specific contract? AECOM responsibilities under this contract, in which you would have indicated, previously about the cap and how payments would have had to have been made.
Mr. Chairman, we had a very detailed scope of works for AECOM. The services involved: A, utilizing, and is that in the document?
Yes, indeed.
All right. If I might just, I don't know you summarize, but anyway, utilizing the substantial work on the project already carried out by the Ministry of Works and Transport without redoing such work. So they will use the available information. Assisting NIDCO with defining the procurement approach. Advising on the most cost-effective and efficient way of finalizing the designs for the project. Preparing design documentation, for those packages that have not already been designed. Dealing with preparation of bid documents and bid packages. Assisting NIDCO in preparing and issuing requests for expressions of interest and tender documents, preparing formal evaluation criteria, and managing the EOI and tender processes, and subsequently reporting to NIDCO and the government of the Republic of Trinidad and Tobago on the outcomes. Assisting NIDCO in preparing and issuing the tender version and final version contract document. Right? Assisting NIDCO in carrying out technical negotiation and assisting in the preparation and finalization of the works, and if relevant, operations and maintenance contract or other forms of contracts. Assisting NIDCO in relation to NIDCO procuring project financing, it is if it so elects. J, procuring reasonable technical resources or special support services for the project.
So clearly, there's spelled out in that contract significant responsibilities of AECOM, correct?
Yes.
As you would have, sorry, Chair?
Yeah, if I
Yes,
could
of course,
just
Chair.
interrupt your flow. I think, Mr. George, I think we, just for clarity purposes for the viewing public, the May 2009,
right,
the contract, that's it, contract you were referring to with AECOM, right? I think we have to bear in mind, based on the fees that based on the payments and the fees that you outlined earlier in response to the question from the member, that was not for the, and correct me if I'm wrong, it was not for the extension of the Solomon Highway to Point Fortin. What we are talking about for the 2009, if I am reading your responses correctly, is for project management consultancy services for phase 1 of the National Network of Highways project. And I think that what the fees that you would have called out there would have been in connection with phase 1 of the National Network of Highways project. Because regarding AECOM, there was, according to your responses here, there was a contract amendment number 1 that was dated October 3rd, 2011. And that contract amendment was executed to amend the principal contract, which is the 2009 contract. And that amendment was to provide construction management services, according to your response, related to the Solomon Hochoy Highway Extension to Point Fortin project. So I just want to be very clear that we don't mix up the two. And actually, the cost of the amendment, number 1, with AECOM was US $47,438,290. So, yeah, Ms. Farmer, am I correct there? That,
yes,
so we have to be careful that we're not mixing up.
No, you've summarized well. What the member was asking about was the 2009 contract.
Yeah.
So what the chairman was discussing was the scope of works, because the document speaks first to that. The scope of works for the 2009 contract and the cap fees for the 2009 contract. Subsequently, in 2011, after the award of the contract to OAS, AECOM's scope of work was amended, and that's what we speak to now about the amendment, and that's what we discuss on page 6,
right,
which speaks to the 47
I just wanted the clarity for the viewing public.
Yeah.
Because
so there are two
not
emails.
having access to the documents, we're talking about AECOM, and they would know AECOM were the appointed project management consultants for the Point Fortin project. But just to let them be aware that that came out of a previous contract,
correct,
a more overarching contract that was tied in with the National Network of Highways project.
Correct.
So I just wanted that to be absolutely clear. Yeah. Yes, members.
Thank you, Chair. Now, so again, and thank you, Chair, for, of course, clarifying that for the benefit of the listening public. So can you say then, did AECOM monitor financial transactions between NIDCO and OAS? Did they monitor financial transactions as a part of their responsibilities between NIDCO and OAS? Yes?
Okay, so, Mr. Chairman, so referring now to the 2011 assignment.
Yeah.
At that time,
about that,
yes,
the OAS, she mentioned.
Yes.
OAS.
Right. Okay, so we can speak to that.
Yes.
At that time, AECOM was employed now as the project manager stroke FIDIC engineer for the project. And as the FIDIC engineer, one of the functions of the FIDIC engineer is to receive and assess claims from the contractor. So AECOM will, payments to between that NIDCO makes to OAS will be triggered by a claim which will go to the FIDIC engineer.
Right.
They will assess and produce a recommendation that will go to NIDCO. NIDCO will look at it and assess it and check it, review it. And once agreed, of course, the IPC will be issued, and NIDCO will be guided by that issued IPC to make the payments to OAS.
So it's fair to say that AECOM was responsible for certifying payments?
That is correct, Mr. Chairman.
Now, for the benefit of the listening public, what is meant by certifying payments? When you say an entity is responsible in contractual terms for certifying payments, just for the benefit of the layman, what does that mean?
Okay, so a contractor does work on site. So at the end of the payment period, the contractor will quantify the work done. Up to that time, it's just a claim that the contractor is making.
Right.
That claim will go to the to AECOM, and AECOM will go through the claim and ensure that it is correct and it is reasonable.
That the works are done, that they're satisfied, that it met whatever standards, and then certify.
That's correct.
Now,
can I just interject again for the benefit of the listening public? IPC, we are referring to the interim payment certificates, right?
Yeah.
Just for the benefit of the viewing public, because we use these terms, and it's the interim payment certificates that are actually guided by the procedures outlined in the conditions of contract.
Thank you, Mr. Chairman. That's quite correct. Yeah.
and just as a part of the flow, who was the ministry liaising with AECOM at this point in time? Which ministry was in contact liaising with AECOM as it relates to instructions, guidance? Which ministry was liaising directly with AECOM? Would you be able to say?
AECOM reported to the employer, NIDCO.
NIDCO.
NIDCO will then liaise with whoever, well, in that case, it would have been the line ministry, Ministry of Works and Transport, so that when that IPC is, well, the interim payment certificate is eventually produced, it is sent to the Ministry of Works and Transport. Through NIDCO.
But just interject, I think what is important to note is that the interim payment certificates, after the certification was done and signed off by AECOM, NIDCO also signed that interim payment certificate, right? Before it went to the Ministry of Works.
That is correct, Mr. Chairman. Yes. So, NIDCO.
Would you be able to say if there was anyone from government that was perhaps a point person dealing with AECOM directly? Would you be able to say if that would have occurred based on the structure you would have identified? Do you know if at that time the records that you would have had before you in the creation of this report, would there be any evidence or any information to suggest? So you have identified what the ideal situation is, how that procedure ought to have worked, that, you know, communication, exchange, payments, all of that. But do you know if at all there's any evidence of any member? And that's why I asked the question about the ministry. But would you be able to say at all if there's any evidence to suggest that there was any person, perhaps, or anyone from government, anyone, that perhaps was a point person dealing directly with AECOM?
Mr. Chairman, I've identified what the de facto situation was, not the ideal.
Okay.
So when it went to the ministry, I will have to defer to the permanent secretary of that ministry, and they will tell you what arrangement existed in the ministry to treat with submissions from us. But I can tell you who the point persons were at NIDCO treating with this.
Okay, and you want to be able to identify those persons at that time?
At the time, it was the senior project manager, and so it will go, and it was that. Yeah, we had a senior project manager assigned to the project, who is no longer with NIDCO. So I don't know whether it's fair to him to sort of name him, but he was that person. So he will receive the information from AECOM. They will have meetings and so, and they will go through the documents, and he will sign off on those documents. So once that is done, it is then sent forward to the ministry. And as I said, well, of course, it goes to the president. The president of NIDCO will then transmit it.
Okay, so I know we would have moved from 2009 to 2011 and so on, but just to bring us back, so we would have dealt with what would have occurred in 2009. I just want to take us now to 2010. Specifically, page 11 of that report, dated again the 31st of October, 2023, that you would have submitted. Now, in 2010, based on the report inter, NIDCO advised OAS of their preferred status.
Member Saga, sorry to interrupt.
No problem, Chair.
But before we move off the AECOM, the services provided by them, I think in your answer to page question 6 under objective 1, on page 3 of 36, you did refer to a directive from a ministerial committee for infrastructure projects, which was a cabinet-led committee comprising cabinet members, leadership and technical representatives of Ministry of Works and Transport and NIDCO, and other technical and legal consultants. So I think in your response there, you did mention the genesis for your engagement with AECOM. It was on the directive of that ministerial committee. So that, just to point that out for clarity as well. And then you stated that NIDCO was charged with the responsibility to contact 8 selected international transport infrastructure consultancy firms. And then you stated you were only able to contact the following 6. Who selected those firms? Who did the shortlisting? Was it NIDCO or was it the ministerial committee advising NIDCO? Or did NIDCO have the responsibility to do that shortlisting?
The ministerial committee, of which NIDCO was part of that committee, wasn't it?
Yeah, it stated here that you were part of that committee.
Yeah. So that committee will collectively...
They did that initial selection.
Yes, Mr. Chair.
And then it was passed to you to
implement.
Okay. Okay. Sorry.
As you're on the point of the minister, because I was coming to that along the road of trying to put this in context and chronology wise. But as we're on the point of the ministerial committee, for the benefit of the listening public, would you be able to identify which entities or which ministries made up that interministerial committee? And it's in your report.
Is it covered in one of your appendices?
It's in appendix 2.
Do we?
So, through you, Chair, the information is provided in Appendix 2, and there are a list of names, in particular, Chairman and Minister in the Office of the Prime Minister, Ministry of Works and Transport, Minister of Finance, Minister of Local Government, Minister of State and Minister of National Security, Attorney General, Parliamentary Secretary.
For the benefit of the public, when you read the title, could you also just indicate again, remind me of the names of those persons?
Through you, Chair, the information, as I say, stated in the appendix, Dr. Honorable Lenny Seed, Chairman and Minister in the Office of the Prime Minister, Honorable Colin Wimber, Minister of Works and Transport, Honorable Karen Nunes Teixeira, Minister of Finance, Senator the Honorable Hazel Manning, Minister of Local Government, Honorable Donna Cox, Minister of State, Ministry of National Security, Senator the Honorable John Jeremy, Attorney General, Honorable Neil Young Hippolyte, Parliamentary Secretary, Ministry of Works and Transport, Mr. Jeremy Hospitalis, Coordinator, National Strategic Management Group, Office of the Prime Minister, Ms. Keisha Inns, President of NIDCO, Ms. Jagannath Soon, Deputy Permanent Secretary, Ministry of Works and Transport, Mr. Maurice Sood, Permanent Secretary in the Ministry of Finance, Mr. Rossini Castro, Program Director, Project Implementation Unit of the Ministry of Works and Transport, Mr. Keith Eddy, Members Board of Directors, Mr. Sean McDonnell, Project Director, Trinidad Rapid Rail Project, Mr. John Bellhouse, External Legal Counsel, NIDCO, White and Case, Ms. Pupak Joe Shaw, Specialist Legal Consultant, NIDCO, on secondment from White and Case, Mr. Dave Montgomery, AECOM, Mr. Raymond Ellis, AECOM, Mr. Joseph Moss, AECOM, Mr. Scott Cooper, AECOM, Mr. Alim Bakora, AECOM, Ms. Yes. Members of the Ministerial Committee, yes.
Thank you very much. Now, again, back to you, back to you, Chairman. Again, page 11 of your report. On May 25th, 2010, NIDCO advised OAS of their preferred status. What from that report that you would have submitted, I understand negotiations there was an intent for negotiations to begin on June 7th, 2010. However, negotiations, again gleaning from the report, actually began 7 months later, between January 5th to January 14th, 2011. Would you be in a position to say what were the reasons for the delay in these negotiations?
Before you answer, Mr. George, Member Sagram, sorry to be
No, Chair,
so
that is no problem.
But as things come up, it's better to get them clarified. I just want to, based on the list that was read out by Mr. Harry Charan, right? He mentioned about four names of persons from AECOM on that ministerial committee. And my question is, how come AECOM have representatives on that committee when they were being evaluated for the award of a contract?
Mr. Chairman, I found that was curious myself. So let me check that and get back to you, because there were other ministerial committees that were operating at the time. So I don't know whether the wrong ministerial committee was what was read out there. But I found it was, it wasn't correct.
Yeah, so I think we need to get that clarified, please, in writing, because there's a conflict there, clearly, based on what was read out.
Mr. Chairman, if I might, when I reviewed the submissions from NIDCO and from Ministry of Works, and even one of the initial notes I had here to ask was if this tender evaluation committee or this evaluation committee was an overarching committee that may have changed from time to time depending on what stage the project was at, or if there were evaluation committees set up by the individual entities while the process was going on. And the reason I ask is because there was an evaluation committee as laid out by NIDCO in their submission that would have been responsible for selecting AECOM. And then there was an evaluation committee as part of Ministry of Works and Transport's submission that would have been responsible for selecting OAS. And AECOM would have been part of that evaluation committee. So I don't, if I might just, my only question I want to ask at this stage is, was there a single evaluation committee that may have had members or persons coming into it at different stages of the process, or were they separate committees that may have been set up by Ministry of Works and Transport, a separate committee set up by NIDCO to evaluate a specific stage of the tender, a specific stage of the process, and a specific a specific tender that needed to be evaluated?
Mr. Chairman, usually there is an evaluation committee set up to evaluate the particular tender. So the committee that would have been used to evaluate OAS's submission, OAS's bid, would be, there may be similar, let's say the representative on that committee, let's say from the Ministry of Works, might be the same person that the ministry would have used on another committee. But for all intents and purposes, the committee that did the evaluation of the bid was separate and independent. There would have been other committees that I think that is where the confusion or the error occurred. But I'll clarify that and get back to you.
Please, if you can clarify, because the committee won't want it be left unanswered because of that. Based on the list that was read out, it's a clear conflict of interest. If AECOM is being evaluated and they have representatives on the committee. So I think it's probably an error and it has to be clarified. Okay? Yes, Member Sukla. Oh, sorry. Yes, sorry.
Just one question, please, Chair. Now, through you, and I'm asking because I'm following the line of my colleague and I understand precisely why she's asking these questions, but I must admit, I am not a lawyer. So I find it very difficult, Chairman, that they're answering questions for something that happened that they were not there for. So I went and I Googled, because Google is my friend, and I looked at the NIPDEC board that more or less was in charge then, right? NIDCO. And the question that I want to ask, if you all are aware where these persons, because for the entire management to disappear, except for the gentleman who has slowly worked his way to the top, because it's been quite some time, absolutely no connection anymore with NIDCO. These people that were at one point in time would have had a fundamental part. And I'm an English major. I love the word saga, because a saga is indeed a tale. And this has been a very interesting saga, but it is a saga that involves the people of Trinidad and Tobago. And I appreciate the great details that you all are answering these questions, but there must be some level of frustration to explain the process, correct? So, Mr. Chairman, I just really want to find out about those, through you, those persons that I really think they should be here answering some of these questions, because I want to know. All right? Thank you.
Well, Mr. Chairman, NIDCO does not have the subpoena powers to call those people forward to sort of testify. But what we say, that doesn't mean to say that the record cannot tell the story. I'll give you an example. Well, we are talking about May of 2010.
Correct.
May 25th specifically.
Yeah, right. So I'm going to address that, but let me just talk about what happened. Well, we know who the board was at the time. The board had a special meeting on May 20, 2010. Yeah.
May 25th, 2010.
Well, yes, but I want to just take you back just before that. Right.
Yeah.
So the board had a special meeting. And what the board said the minute of that special meeting says, the board noted the evaluation committee's recommendation that NIDCO enter into negotiations with Contractual OAS Ltda as preferred respondent and GLF Construction Corporation be the reserve respondent. In light of the above and after consideration of the package 3 report, that is a report that said that those people will be ranked as stated, the board approved the said report. So they're approving the report. And subject to the obtaining of a no objection to proceed from the minister, recommend that NIDCO enter into negotiations with, right. I went there to point out that the board of the day, before they left the meeting office, they had a meeting and they did say they accepted the report from the evaluation committee, and they said, well, those persons should be, the persons ranked as I have outlined should be approached as far as the negotiation was concerned. But that must be done only if it receives the approval of the minister. There could not have been any minister of works one day after the election.
Wow.
There was no minister of works at the time. Well, yes. So I'm saying that that I found was strange. Why was it done? Right. So I just asked the question. And more than that, what was the effect of it? Because even though it was done in 25th, it was very short-lived, because the record again shows that soon after, on the 30th of May, a notice was issued rescinding that one that was given on the 25th, telling OAS that they have to get the ministerial approval, and they will revert at some stage when that is in place. And in fact, it did take place, and they got back to OAS the following year. Is it?
Just the end of 2010 for the negotiations.
Oh yeah, they started 2010, and of course it spilled over in 2011. So the question is, well, that ought not to have happened based on what the board at the time recommended. So, Mr. Chairman, I know I take your advice, but all of that contributed to the saga that I felt it was. It ought not to have happened. There was no line minister to give non-objection on the 25th. Is it one day? One day after an election.
Chairman, if you don't mind.
Yeah. We'll continue with the timeline, trying to start the timeline. But in between, what we are doing is allowing other members to interject. I am myself interjecting, so that as we go down the road, based on the questioning by Member Sagram Singh Sukral, we're using the opportunity to get the clarity as we go down and clarifications. So I'll allow Member Denobrega.
Thank you, Chairman.
Yeah.
Thank you, Chairman. Chairman, through you, and Chairman George, there were a couple comments that you made in your opening, and something you've just said, I just want to draw reference to. We spoke about the wording, as the Chairman said, the name was assigned to the report. Given what you have said, you initially said a colorful history. I wonder if a more apt term would be a convoluted history. One thing I want to clarify, Chairman, which I think will guide my questions during this process. there should be, and I think you alluded to it while you were speaking earlier, there should be an active interface between NIDCO and the line ministry. You spoke about this when we were defining that NIDCO was the employer, right? But there should be an active interface. The board of NIDCO should be interfacing with the line ministry, keeping them abreast of what is happening on a project and all of these things. And I just want to clarify from you, one, if that is a correct assertion or a correct assumption on my part.
Mr. Chairman, it is correct and it is practice. I recall having NIDCO that is having fortnightly meeting with the current Minister of Works, and the purpose of those meetings was to apprise him as to what was happening on all the projects NIDCO was undertaking. Where are we? What is happening?
Yeah.
And that's an ongoing arrangement that exists between NIDCO and the line ministry. So it is not just a arm's length arrangement. There is a I'm tempted to say collaborative, but collaborative.
So,
but Mr. George, let me just, based on what you're saying there, was it concretized in that, based on your understanding, your relationship, or the job you were given to do with by the government of Trinidad and Tobago, did NIDCO produce regular reports, like regular progress reports, monthly reports, to the Ministry of Works and Transport or Government of the Republic of Trinidad and Tobago as part of your mandate?
Yes, Mr. Chairman, that was done. And in fact, every time an IPC was generated to be sent to the ministry, and IPCs, that is the interim payment certificates, are usually done on a monthly basis. So every time that is generated, a report accompanies that IPC, outlining the progress that was made during the period. That is to say, the last month. Yeah, so it is done.
Thanks. So, Chairman, your response to me preempted my next question, or my next assumption, that active interface really is because the line ministry, and I say ministry/minister, as you have also outlined, is responsible for guiding policy, and NIDCO as an actioning agent of that policy. So obviously, line minister will want to ensure that the actions being undertaken by his actioning agency are in line with his instructions, which are reflective of government policy. Correct?
That's right. Correct, Mr. Chairman.
All right. So based on that, I don't know if you can answer for past boards. I don't know if the reports that you all would have gone back to, the information is available to you, will be able to guide your answer. But any major decision that has to be taken on a project, and in particular decisions critical decisions that would be relevant to project scope, critical decisions that would be relevant to project finances, and in particular changes to those things, to a work plan, those things would typically be a conversation that would happen, would be part of a conversation that would happen before a decision to action would take place?
Yes, Mr. Chairman, especially if the cost of that planned revision impacts the budget. A budget may have contingencies. So if something has to be done and it can be taken from the contingency, then the project manager, that is NIDCO, could sort of make a decision with the the FIDIC engineer, and that decision must be communicated with the line ministry. But you know, for the non-objection. So the line ministry would like to know, well, okay, yes, that is a change that has to be made. It has been recommended and what have you. It has to be made, and the cost of so doing will be coming from the contingency, and that is not needed, because what if the contingency has been used up and additional funds are required? That might then be, you might then have to do a draft cabinet note to send to the ministry, so the ministry now can approach cabinet for increased funding, which one tries not to do. Manage in such a way that you can do what you have to do, in the budget that has been approved.
I appreciate it. Okay, so Chairman, I like Senator Saga Singh Suklal, also want to backtrack a little bit, right? We have spoken about the genesis of what became this project. We've spoken about where we've come from. We would have gone through a selection process that would have selected AECOM as the consultants. AECOM would have been responsible for a long laundry list, as you would have pointed out, and ultimately would have been a contributor as part of the evaluation team that Ministry of Works would have laid out in their contribution for the selection of OAS, or for OAS being the selected bidder. Am I correct in that?
You're correct. The evaluation team was responsible, and on that team there will be representatives from the ministry.
They would have formed part of that team.
Yeah.
So, what I would like, because as we are discussing the timestamp, I do think we need to insert some detail in between our milestones. Right. So, can we discuss the process by which OAS was selected, and on what basis OAS would have been selected? I have seen your report, and your report does speak to it, but as we've said, this is also for the benefit of those listening and looking at this. On what basis was OAS selected? What were the criteria? And if we can just go into a little bit of detail around that.
Okay, so Mr. Chairman, the basis is outlined on page 9, 10, and 11 of 36, and basically it is reflective of the process, the tender process that we spoke about earlier. So AECOM is working now along with NIDCO. AECOM worked and produced requests for they call it RFP, request for proposal, that will go out now as the tender invitation to bidders. So that was done, and it went out to, right, it was open tendering. So it is people invited. You had 10 local contractors tendering, buying packages, and along with, what we find? All right. Well, I'm being told that there were 29 in all, 29 tenders purchase packages, and in that group of tenders, 10 of them were local contractors. So the RFP has all the information required. What has to be done? It has the evaluation criteria in there as well. Fast forward, so then that went out. So the tenders went out on the
hold on, I have it written here. Is it? All right. Anyway, tenders closed on May 7, 2010. When did it go out? Yes, it went out on February 26, 2010. It closed May, what did I say? May 7, 2010. So when these bids came, all right, so the bids came in from how many people? From 3 people. Or 29, it whittled down to just 3. There was an evaluation. Good, yeah, so there's an evaluation committee who will come and assess and evaluate the bids received using the objective criteria that was stated in the RFP document. There was so the tenders were evaluated between May 7 and May 13. So you had, 6 days of evaluation. At the end of May, at the end of the evaluation, the tenders who were rank ordered would be OAS and who was the second person? All right, so we had OAS, GLF Construction, China Railway Construction, those 3. And OAS was determined to be the preferred tenderer. The amounts or the bid prices submitted by those tenderers would have been $5.285 million by $5.285 billion by OAS, 5.378 by GLF, and 6.366 by China Railway. So you had the evaluation, and there was a recommendation coming out of that evaluation. This is what we spoke about earlier when we said that when the special board meeting on the 20th of May spoke to the evaluation committee's recommendation, and where the special board meeting is saying we accept the evaluation. So the report now would have been sent forward, right, through the tenders committee of NIDCO, and then that will go to the board. So the board met on the 20th of May, considered the report, and said, okay, we support the recommendation, and there should be negotiations now with OAS and GLF, subject to the non-objection of the line minister, and that's what I spoke about earlier. So basically, that was the process.
So, Jeff.
No, you. Member Ibrahim.
Good afternoon. Well, Chairman George, you have actually answered my question that I was looking to ask at this stage, which was at the time of the evaluation of the bids, generally, what was the value then? At this point in time, along the timeline that we are establishing, there has been no award of contract. Okay, we have gone through all the permutations and checked which is 3 individuals or the 3 companies who tendered for, but you had answered already that OAS came in at a $5.285 billion value.
Yes.
Just like Maurice Julian and others on the committee, I'm not an engineer by background, but I know in these processes, there's definitely guidance from when the tender packages are being put out that the engineers would suggest, based upon their scope of works, what they believe for internal purposes, what this project should be. For public knowledge and clarity, where did that lie within the engineer's estimate, and how far off were these bids when we received.
Mr. Chairman, I cannot directly answer what was the engineer's estimate for the project. I'll have to check whether one existed, and if it did, then I'll have to make that available.
Okay. Well, related to that, because we are at the time, we're at the stage of establishing tenders and receiving bids and tenders and so on. There's something that I would like to understand at this stage, and both either yourself or the Ministry of Works can answer. Were there, before even the tenders were put out or the scope of works were placed, and I want to relate it to local content, because we recognize that 29 companies did show interest. We do believe that 10 of them were local, right? However, no one came forward on a local level, maybe for whatever reason. Scope of, we will never know because a bid was never placed. But something that I believe may be fundamental to that process and selection was the design build model, which was recommended by AECOM versus the design build model. Did the Ministry of Works have any objections or concerns in relations in using a design build model for a project this size?
Okay, before you answer, Mr. Ziawara, Mr. George, just to, in terms of the engineer's estimate that you mentioned, Mr. Haricharan could probably guide us, but there's an appendix in which the evaluation report was attached, right? And from my recollection of going through that evaluation report, there is mention of the engineer's estimate, but it is mentioned as a footnote. There's no detail. And from what I recall reading that appendix, that evaluation report, is that the bids received by the three tenderers were substantially higher than the engineer's estimate. And the reason put forward by the evaluation team was that AECOM estimate was off by that amount because the scope of the work, they did not take the full scope of the work into account in coming up with the estimate. But I would just like to refer Mr. George to that evaluation report, and if you could check back regarding the engineer's estimate, and other than the footnote or the statement about the difference, I think it's just one or two lines from what I remember. If NIDCO would be able to provide us with any more details regarding the substantial difference that there was between the bids that were received and the FIDIC engineer's estimate. Yeah, so I just want to mention that before you respond to Member Ibrahim.
Right,
in terms of the design build model, I think he was asking about.
All right. We shall find that engineer's estimate and make it available, Mr. Chairman. It is also true to say that AECOM was given an assignment to look at modes of procurement of the facility of the project, and so they had looked at design bid build, they had looked at design build, and there is one that is I know that I trip up on whenever I have to call it. Is it what? Anyhow, acronyms for design.
It's more. The other one is more like
a boot, you know.
Like a construction management, where the at risk.
Yeah,
Let's talk about
there is that.
Contractor risk model.
Right, and then there is another one called design, build, maintain, operate, maintain, and transfer. So they looked at all those different models, and they recommended that the design build was superior for the present project. And without kind of going down into the reason why that might have been so, the good thing about design build model is that you have the design risk and the building risk centered in one entity. Now, when you go that way sometimes, well, not most times, is that the scope of the project changes. So we might find local contractors who are quite capable of doing the work, but they are not prepared to take that risk and even to find the funding required to fund it. So as I said, AECOM looked at the options and advised that design build was the more attractive one.
But NIDCO accepted AECOM's recommendation.
Yeah, yes.
Right, because I think it's there in one of the appendices.
Yes.
In terms of the evaluation exercise that was done for the procurement strategy. Yes. And but that was NIDCO at that time. But I'm not sure if your current team have had the opportunity to look at that procurement strategy report of AECOM and what your thoughts are regarding the model that was selected, which is the design build model.
Well, I like the single point risk allocation, but after the project floundered and we had to take other steps, Plan B came into being, where we already had a design for most of it. We had some additional design work to do. We had a design for most of it, so we were able to not compartmentalize, but to cut up the project into smaller pieces, smaller packages, and go out to tender. And in that case, what was used was design, bid, bill, right? So the design was done now by the employer, and then an RFP was sent out to procure the services of contractor to just do the construction work. And that is what was used to deliver the project upon the demise of OAS. So they have advantages, and the convention, the conventional approach is the design, bid, bill, right? Almost any project can be done like that. But when you are dealing with some project, it might just be a little bit more attractive and convenient to go the design build. Right?
I notice you use the word attractive rather than tempting. Because I went through that procurement strategy report of AECOM. And with my limited experience in the whole thing, is that you can generalize in terms of the different procurement models. And I was a little concerned of the lack of specificity with regards to the actual project and the conditions under which the actual project had to be executed, both the design and the construction. And what is tempting, I think, with design build model as a procurement strategy is that there's often the thought that we'll get the product much faster. That's one. And that's attractive for certain clients, because we can deliver it earlier. it would cost, and I think there are persons with vast experience here from the respective entities in terms of that, of cost. And there would always be that debate whether which methodology costs less at the end of the day, at the end of the day. And, there were certain assessments along those lines, which was a bit general in my view. But, I mean, that was the model that was selected. That was recommended by AECOM. That was the procurement model that was accepted by NIDCO, and that was accepted by the government at that time. Yeah. Which is why I was just seeking, in terms of the current team at NIDCO, whether you had any views on the model being the most appropriate one for the project.
To talk to whether, Mr. Chairman, whether it is the most appropriate one for that project. But from what I have experienced, working in the industry for a number of years, I'm not prepared to throw out the design bid build model yet. I find there are significant advantages there. I tend to like it. Maybe I'm old-fashioned, but I tend to like it.
Because I think Member Ibrahim did touch on the question that about 10 local contractors collecting documents, but they did not submit bids. And it could be the scope of the project, because the design build model calls for a contractor to be a lot more organized, to be able to cash flow a bid process, because you have to get designers involved as well in the bidding process. And a lot of times the design element of it, the prospective bidder has to pay for that design service on which to base his bid on. So the cost jumps up a lot for the bidder. And it could have been a deterrent for the local contractors for such a complex project. And I just wonder whether the selection of the procurement model just excluded, just by selecting the design build model, excluded local contractors because of the model we went for. Rather than, because prior to that, there are several projects done under IDB funding, World Bank funding, where the desire is to maximize local participation to boost the local economy and all of those things. And the chopping up of projects, I just use the word chopping, not in any drastic way, but the dividing up of the projects, which is what we reverted to at the end of it. Because, for instance, like the priority bus route from Aruka to Arima, maybe you recall that project. Mr. Ramsingh, I'm sure, would recall that project. Or the extension of the Churchill Roosevelt Highway from Kirap to Takariga and then up to Arima under IDB funding. I distinctly remember, in order to ensure, after the experience with the foreign contractors, like Higgs and Hill and all of these people, the project was divided up, that it fell within the means of local contractors, which is still significant means. I don't underestimate our local contractors. And it was divided up. But the design was done by one entity, and the documents were prepared. That way, local contractors were able to do the entire project. And this design build model that was adopted for this particular project, the Point Fortin extension, whether just by the choice of the procurement strategy, it negated or it minimized the role of local contractors.
Chairman, I'll
Because
have
of
to
the
agree
reasons
with
I
you.
said.
I'll have to agree with that because the experience will show that once the thing was resolved into packages, look at what happened. They're all done by local contractors. And we have all benefited. We have helped to, or that has helped to sort of grow the capacity. And going forward, it might be, it might be prudent to hold on to the design bid bill, if only to encourage our local contractors to be involved, because they have been involved. I mean, and the other projects that we are doing, where they are involved, we have not had any problem with them. We have 12 packages, or we had 12 packages down at that highway to sort of continue the highway, and they were all handled by local contractors with whom we are all pleased. All right, so.
Okay. Not that Mr. Harrison.
Through NIDCO's chairman to you, Chairman, and you made reference to the engineer's estimate. I thought it might be fitting to advise that the engineer's estimate, as you alluded, is included in Appendix 7. The number, in particular, the evaluation report E7.1, and it refers to a number of 4.17 billion. And that particular number, as you would have advised, it is in reference to an assumption made, in particular, 45 kilometers was the engineer's estimate was based on that 45 kilometer, of which 22 kilometers was designed. In that regard, they made assumptions on the remaining lengths, hence the reason for, and that discussion was included in the report. Now, if again through you, Chairman, there was an earlier question in relation to lead to plans estimate. I advised that that number was not included in the appendices. I have since perused the information, and it is available in Volume 1, Clause 3.4. And in that discussion, the lead to plan at the time advised that the construction cost for the highway is $2.6 billion, and that's a 2006 estimate. So just to correct the records in that regard.
Okay, thank you very much. Before we move on, just to, I'll just add something in that, not that I'm expressing any bias towards or negativity about design build model. It has worked for us as well successfully on some projects. And I think I must mention also that the OAS contract did a significant element from the documentation that I've gone through, had contractually, I don't know how much of it was achieved, that 40% of the contract had to be done by locals. So I think, despite all we have said as well, I think for balance, we also have to recognize that efforts to maximize the local inputs were also made as well, because I don't want to get the public to get the impression that it was not done. But contractually within the OS contract, allowances were made for up to 40% of local participation. How much of it was actually done? Well, we haven't seen the data, or we haven't seen the information to determine how much of it became reality. But the intention was there to address the imbalance that we would have been alluding to. So we are 12:30, and what I suggest is that the meeting be suspended. We'll take a 1 hour break for lunch, and and we resume at 1:30, where we'll continue our exercise. So thanks everybody for the session, and see you here at 1:30. So the meeting is hereby suspended. Okay, just to advise that we do have lunch available for everyone. Okay, I'd like to reconvene this meeting. First public hearing regarding the 2023 NIDCO report inquiry, and to welcome all present to our second session, and of course to welcome our viewing and listening public. So we'll go straight in the continuation of following our session this morning. And before I ask Member De Nobrega to lead us off, I just want to go to page 12 of 36 of NIDCO's response. We were discussing the date of May 25th, 2010, coming to the end of this morning's session. And in response to question 2, in which the committee had asked for a copy of the letter dated May 25th, 2010, advising OAS of their preferred status. NIDCO did respond by saying, please refer to Appendix 10 for a copy of letter dated May 25th, 2010, in which NIDCO notified the OAS that they had emerged as the preferred bidders following the tender evaluation process. Mr. Haricharan, in checking Appendix 10, the letter that is in Appendix 10 is actually not the letter advising OAS that they would provide bidder, but actually the letter of intent that's dated March 4th, 2011. At least when I checked Appendix 10, it is not the letter.
Yes, I confirm. I'm looking at the information now, and that would be an error in the reference. Correct. So permit us, we will provide that letter subsequently.
Okay, thank you. Yeah, Member De Nobrega.
Thank you, Chair. So we have gone through the morning session, and we established that we had a process that started really in 2009 and had gone through with the selection of AECOM and had gone through an acceptable process, and we have arrived at a tender being put out, OAS being selected. And if you are right with it, Mr. Chairman, that is where I'd like to start. So, Chairman George, and of course, if members from Ministry of Works and Transport can add as well, we have a process whereby by May 13th, tenders have closed off. An evaluation process has been undertaken, and you have arrived at a selected bidder. But of course, Chairman, as you would have pointed out, while all this was going on, there was a very significant event that took place in this country, and an election would have been called, I believe, sometime in mid-April. Election was held on May 24th, and against the backdrop of that, a decision was taken to not engage with anyone prior to the election. Am I correct? Yeah? Yeah, sorry.
Yes, Chairman. He is correct. The member is correct, Chairman.
So, can I ask, how was that decision conveyed to NIDCO? Was that a conversation? Because we did speak about there being, there being an ongoing relationship that was necessary for the line ministry and minister and the board of NIDCO to always be in contact with each other around major decisions. So was it that at that point, NIDCO would have received a verbal instruction, the board would have received an instruction, was it written? How was that decision conveyed to NIDCO?
Mr. Chairman, I couldn't see sorry, how the instruction was conveyed. What I can see and have highlighted is the fact that NIDCO's very board met and they had a special meeting and they were saying that they had decided that negotiations could be, you can have negotiations with those, they're accepting that recommendation for what's his name, OS to be the preferred respondent, followed by GLF. And they're saying, okay, yes, you can have negotiations, subject to, right? So it's no longer like NIDCO not knowing, they're not clear, we're not sure how the instructions got to NIDCO, but NIDCO has the instruction because the board is saying, don't pass go, hold on until such time you can get a non-objection from the line minister, whoever he might be. And what we are saying is that that was not defined. He was not defined on the morning of election. So whoever did it at NIDCO, and I say I don't want to give my opinion, but I can only say that that person acted, did not act based on the instruction given by the board that was responsible for the sort of strategic guidance of the enterprise.
So, Chairman, I feel as if you've taken a look at some of the questions I have here, because and in there is where I have one of my first real issues here, because given what you have said and how I understand it as well, the board has taken a position that I agree with. The board has said that we have a major event that is about to take place. This is a massive construction project worth an immense amount of money, and we don't want, in the lead up, to taint the decision to award any contract to someone in the lead up to that. So let us hold stream, right? However, NIDCO is not a person. NIDCO is an entity. So NIDCO cannot make a decision and write a letter in and of itself. It requires a person to do that. And that person, I suppose my first question would obviously be, who is the person that would have written that letter, and where is the instruction to write that letter or the approval to write that letter? Because that must exist, especially if you have a previous decision that has been communicated that nothing is supposed to be done until you get clearance from a line minister. And I think we can all accept the fact that on the morning of the 25th, there was no line minister in place. So that is where I'm having my first bit of difficulty. And I know, well, we had hoped that that letter would have been in the package, but we're looking forward to getting that. So if you can give me some clarity as to how that came about and who would be the person responsible for that.
Right. Mr. Chairman, I can advise that based on the record, the letter was written by or was signed off by someone on behalf of Mr. Milton Harris, and he was the secretary of the Tenders Committee of NIDCO. I don't know whose signature is that. So,
and the letter is addressed to? OAS.
All right. And it is addressed to Antonio Roquim Neto. Is that correct? Right. Of OAS.
But all correspondence with OAS would normally come through the president of NIDCO.
No. Well, at that time, it was still in the procurement stage. Communication or correspondence could have been addressed by the secretary of the Tenders Committee. Yeah, and Milton Harris was the secretary of the Tenders Committee at that time. So the letter was written and somebody signed for him. Milton Harris is no longer employed at NIDCO. Milton Harris.
Okay.
And it was copied to the president of NIDCO at the time, Keisha Ince, and the vice president legal, Mr. Nirad Samnada Ramrikasin. So,
Chairman, if I might, through you were saying, Chairman, that mode of communication was an acceptable mode of communication. In other words, having been written by the person occupying that office would have been authorized in his capacity as Secretary to the Tenders Committee to inform. However, there has already been a position taken that is not to be done without approval, and I'm using the word approval, by the line minister, which we accept is not in place. So that letter would have been sent out contrary to an instruction. Correct?
Correct. Within the organization.
Within the organization.
Yes.
Yeah. And as you have stated, and I'm sorry for pressing this, but I want to be very clear, that instruction was not a verbal instruction. That instruction, there's a letter that documents that position, that it is not to be done without approval by the line minister.
Mr. Chairman.
Okay, the special board meeting.
And I might add, Mr. Chairman, that board meetings are attended by the president of the organization as well. So the president of NIDCO at the time would have attended the meeting or ought to have known about the decision taken at the meeting if for some reason he or she could not have attended.
Okay, the special board meeting that you referred to, minutes of that board meeting are available?
Yes, that's what I quoted from, Mr. Chairman.
All right. Is it, Ms. Archer, is that included in any of the appendices?
No, the minutes are not included in the appendices.
All right.
Chairman.
Would it be possible for the committee to get that from you?
We take note of that.
Yes. The minutes of that special board meeting. Yeah. So hand over now to Member Sagram Singh Sukha.
Thank you, Chair. So, Mr. George, let's go back to that report, and as we continue the timeline, we would have stopped, well, at least your and my conversation would have ended about May 25th, 2010. So I want to take you respectfully to the report again, the report that was submitted, again dated 31st October 2023. Page 12 of that report brings us to February 10th, 2011. Now, in that report, at page 12, Mr. George, NIDCO would have indicated that Cabinet approved the award of the contract to OAS. So we're now in the dance where a Cabinet note there's a Cabinet approval, for the award of a contract to OAS. At page 12, it's also stated authorization was given to NIDCO to source funding. The report further says NIDCO initiated proposals from local financial institutions. The report goes on to say, however, government changed plans and decided to fund on an annual basis through cash transfers from the Ministry of Finance and Economy, as the ministry was then called. This approach was used for the years 2011 to 2014 inclusive, and that is a part of your report submitted before this committee, page 12. So again, for the benefit of the listening public, we are now at February 10th, 2011. Now, based on what was stated in your report, and which I would have just read into the record, can you indicate to this committee what was the rationale for this particular change? And the change that I'm talking about is that the part where you said the government changed plans and decided to fund this project on an annual basis through cash transfers from the Ministry of Finance and Economy. In the records that, or the records that are before you, would you be able to at all indicate what was perhaps responsible? Because this is a significant. Would you be able to indicate what was the rationale for this change? Was there any reasoning, any logical reasoning, any explanation why such a significant decision would have been taken?
Mr. Chairman, no, I can't. What I can say is that we got the instruction to proceed as was outlined from Cabinet Minute 333-2011/02/10. And that was the instruction where NIDCO was advised of the approval of the budget, and the budget was 7.502, and the conditions about going out to seek the funding, that was given. So I have where the instruction was given.
Via the minute.
Yes, but what I don't have, so the instruction given and action is being taken. What happens next is that NIDCO is no longer doing that. Instead, NIDCO is being provided with payments, tranches, and in fact received the first payment in May of 2011. Mm-hmm. So that is what I can report. That's what the record shows. But as to why the decision was taken, how it was taken, unfortunately, I can't, Mr. President, Mr. Chairman.
So, well, the regular process is that there's a note that, of course, would have gone before a cabinet. Approval would be given by a cabinet, and that's how the minute is created, and that's just for the benefit of the listening public. The minute is, of course, the decision taken based on the note that is presented to the cabinet. And you are saying, again, it was based on that minute. The instructions in that minute is what you would have acted upon to have this change that, you would have mentioned at paragraph page 12, of your report. You would have just actioned, in other words, the instructions given to you via this minute 3331, I believe, of 2011. 333, sorry, 2011.
Yeah, well, where it is?
Yeah?
Yes, 2011. And I might add, Mr. Chairman, that that was annexed to a letter written by the permanent secretary. So attached to that.
The permanent secretary, just to the record, of.
Pardon me?
The permanent secretary of.
Of the Ministry of Works and Transport.
Right.
So there is a cabinet minute with a covering letter from the Ministry of Works, and it is telling the president of NIDCO, advising the president of NIDCO that approval has been given for the project budget. The budget was 7.5. It is also saying, or advising the, and making reference to the cabinet minute.
Right.
It is also advising the president of NIDCO to now proceed to make appropriate arrangements to pursue the requisite funding.
Right.
So that was good.
So we're jumping in a dance now with funding and monies, because you alluded to NIDCO, or at this stage is where monies are now going to be received by the entity, correct? Based on this minute. Would you be able to identify or say to this committee by this time, what was the total amount of money transferred between these years of 2011 to 2014? Yes, I know it's in the report, but again, for the benefit of the listening public. So we have a significant change being made here pursuant to your report, 10th of February 2011. We understand there's a cabinet minute, and next to that minute is instructions from the permanent secretary of the Ministry of Works and Transport indicating that cabinet has approved that payment for this contract, this work, this project would now be paid through cash transfers from the Ministry of Finance and Economy. So all of that is before NIDCO. What was the total amount transferred between the period 2011 to 2014?
Chairman, if I may just ask
Of
a question
course.
before that question is taken. When we wrapped up just over an hour ago, before the break, what you had mentioned to us, and we were at the point of discussion where we were deliberating between the engineer's estimate and what the contract bid was won at, which I believe was a $5.285 billion figure. If somebody were to rejoin us in hearing our discussions, they would realize that an approved figure is now at $7.5 billion. That is between May 2010, and what we understood is that that was well within the remit of the board of NIDCO to write that letter. However, I'm just asking, what would account for that difference in figure of 5.285 to a approved budget of 7.5 for the listening public?
Okay, Mr. Chairman, I think we alluded to it this morning too. The 5.285, that was the bid price submitted by the contractor. What goes to cabinet for its approval is that bid price, along with all the other ancillary sums. In fact, you have the land acquisition, community outreach, construction contingencies, customs and import duties. So all those things are consolidated to give you that figure of $7-point-something billion. So when the advice is coming back now from cabinet is approving the project budget, and that is what we are advised of. That is NIDCO through its president on February 25. So the 7.5 billion was not for OAS per se, but it was the budget, the approved budget for the project.
No, point noted, Chair, but there's a point of clarity that I wanted people to basically follow the story to understand exactly what would have caused that increase, because we're not talking about million here, yeah? Or even hundreds of thousands.
Chair, I can continue. Thank you. So again, just to close off what I was asking before I jump into something else, what was the total amount transferred between these years from 2011 to 2014? Just to place that on the record.
Yeah. Okay, so, Mr. Chairman, I will now read out the schedule of transfers that were received by NIDCO. It is also contained on page 15 of that saga. So on June 27, 2011, the first tranche was paid into NIDCO, and it was 1.5 billion TT dollars. On August 9, 2012, a second tranche was paid of $1 billion.
Could you just identify the years as well when you say the month, just to the record, month and year?
Okay. Mr. Chairman, I will repeat. June 27, 2011, 1.5 billion TT dollars was paid. On August 9, 2012, $1 billion was paid. Fiscal 2013, the exact 2013. Well, yeah, but I know it. I know. Okay, it is $1.1 billion. It is, and then fiscal 2014, it's $1.5 billion, and that last one was a bridge loan that the government arranged through RBC, RBTT Bank. So the total that was transferred through those bullet payment, transfers was 5.1 billion TT dollars.
Right, and this again, coming back to your submissions, would have been done through cash transfers from the Ministry of Finance and the Economy.
Except for the last one.
Which is the bridge loan.
Yeah.
Okay, now before I come back to, asking some questions on, what those cash transfers and the implications of cash transfers, particularly on, contracts of this magnitude, I want to, again, I started off this morning referring to NIDCO's mission. And what stood out to me, which I would have alluded to earlier on, of course, would have been through a philosophy of managing our business with the highest ethical standards, which is a core value, of course, of NIDCO. Now, that, reminding ourselves of what is core to the institution, the entity, brings to mind the whole concept of FIDIC contracts. And more so, I'm definitely not an engineer. This morning, we heard a lot of talk about design and build contracts. And for the benefit of the listening public in particular, and especially throughout the length and breadth of your submissions, there's a reference to the FIDIC Yellow Book. And that particular book makes reference to FIDIC terms and conditions for what we deem as FIDIC contracts. And this contract in particular was deemed as a FIDIC contract. For the benefit of the listening public, based on the FIDIC Yellow Book, Build and Design, can you just elucidate what is the general gist of FIDIC contracts? What is the core principles or some of the core principles of FIDIC contracts?
Mr. Chairman, I will attempt to answer this question in two ways. I will start and I will defer to
Mr. George, you permit me to interrupt you.
Yeah.
Before you get into the response to members, Sagram Singh Sukla's question,
Of course.
if I could just facilitate member Morris Julian. What happened? She has to leave, and she wants to pose a question before she does that. So if I could just interject, if you all bear with that, please.
Thank you very much, Chairman, and thank you, colleague, for allowing me to go forward. And I just want to welcome Mr. Mohan Singh from Highway Division. It's good to see you, sir. We have already established, Mr. George, now, you are someone I have deep respect for because you have been doing this for quite some time, right? So there's very little you do not know about contracts and the process, etc. In fact, I think you know all, right? Yes, that's a genuine compliment, sir. Right, in February 10th, 2011, the Cabinet approved the award to OAS, right? Authority given to NIDCO to source funding, that has been established, correct? Right? Prior to February 10th, negotiation was between NIDCO and OAS January 5th to January 14th. I think by now you understand what it is I'm alluding to. It was delayed from a planned start date from the 7th of June 2010 to January 5th, 2011. Right? Why? In your professional opinion, because I don't think it's usual to conduct and complete negotiations for this size, this monumental size of project in 10 days. And again, with the experience that you have with negotiations and with construction, and for those of us, laymen and women, if you could just give us a reason why.
Mr. Chairman, I can only speculate. There was a the negotiation committee that met with OS was very high-powered, well-resourced, lots of persons and so met. And maybe it is, as I said, I can only speculate. Because when I look at the results of the report that came from that committee, you see that the bid price went down, albeit by about 77, is it thousand or 7,000, right? Million? No. $77,000. So it means that that contractor was maybe dead on in terms of the scope of works and his pricing. That's my speculation. It is also significant to me that there was an item of work, that is to say, the upgrade of the works from Dumfries Road to Paria Suites. Mm-hmm. That item of work was excised from the tender, during the tender stage. It was done through an Addendum 1. All right, so the RFP went out, and it was in the scope of works. During the tender period, an Addendum 1 was issued saying that item of work must not be there. But during the negotiation, they were able to reintroduce the item of work, and the contractor, accepted, albeit kicking and screaming, but he accepted, and they said that, okay, you're going to be doing that, and the funding for it will come from a value engineering exercise that you will conduct throughout the project. And what that is really is that, okay, you have certain concepts, designs, and so that you have used to prepare your bid. And one can always revisit it, fine-tune it. And whereas something might have been costing you X dollars before, it can, because of your, fine tuning and astute designing, it can now cost, say it was costing 10 before, it can now cost 8. So you have done some value engineering on the design, and you have realized a saving of $2. So at the negotiation, it was agreed that the contractor will now take on board that extra item of work, and the cost of that item will come from his going back, looking at his design and generating savings through a value engineering thing. So I'm saying that that's a very hard sell, and they were able to do it. So I can only accredit them for their expertise and for doing it so quickly and getting so much, achieving so much.
One last question. Expertise, you say, and well, it was definitely expedited. In your professional opinion, is that the norm for something to be concluded so quickly? And from what you're saying also, for a contractor to agree to basically cut their nose to spite their face. You're in a safe space, Mr. George. You can tell us.
I don't have the grounds to deny it. And remember, I promised Mr. Chairman that I will not regale you with opinions that I form along the way. But I'll say this one thing, which is equally alarming, but not. That is not alarming, what we have just dealt with. But the one that I will say now is even more alarming. And with your permission, Mr. Chairman, I want to just talk briefly about Addendum 1. After engaging the project for a while, there were a lot of claims that the contractor was making had made as a result of delays that he was experiencing through protests and all kinds of things. So he had a raft of claims there that he had made. Up came, I already alluded to the fact that he was asked to take on board the work from Dumfries to Parrier Suites, and the costs for so doing would have come from his having to generate savings from value engineering. What does Addendum 1 tell us? Addendum 1 says, after a while, the contractor came back and said that, I can't find the money. I've gone through the exercise and I can't find the savings to be able to finance the work from there to Dumfries to Parrier Suite. The cost of those works, was reported to be 35 million US dollars. So you're saying, you'll have to fund it. I don't have that money. We can't find that money. Additionally, AECOM reports that they estimated the claims that the contractor had submitted at the time. The claims were not fully adjudicated. They were not fully assessed. But AECOM assessed those claims to be US $159,094,659 VAT exclusive. So here is a contractor who has been asked to do an item of work, the cost of which is about 34 million US dollars. He has claims there that AECOM is saying is 159 million US dollars. And Addendum 1 says we agreed to give the contractor an additional payment of $17 million. 17 million US dollars, I might add. And Addendum 1 has asked me to believe that everything is all right It's okay. I'm going to forego all the claims that I have. I'm going to forego the fact that you needed to pay me $34 million US dollars to do the work that you asked me to do, albeit late. I'm going to forego all of that. So I'm going to forego 159 plus 34. And the last time I checked, that was 182, I think. Maybe 190 something. I'm going to forego all of that, except $17 million. And I know, and I'm okay. I cannot understand that yet. But I don't want to give any opinions on it. It's just that I can't understand it.
Through the chair, you don't have to give any opinions. I think we can form our own opinions, and that is indeed very alarming. So work was not completed, but you were paid for work that you did not do. And thank you very much, Mr. George. I think with that one, Chairman, thank you.
Okay, Mr. George, just to add one thing to the negotiations, right? That the Dumfries to Paria Suites leg, when that came up, during the negotiations, that matter was addressed, right? And in addition to the whole issue of the monies for that leg being won from the value engineering exercise, actually the contractor OAS agreed to, even if the money is not achieved through value engineering, right? The price would still stand. The contract price would still stand, and they would still do that part of the work. Even if you look back at the negotiating documents that you all attached in the appendices, so there was an even if monies are not won through the value engineering exercise, the contractor was still prepared, he still signed off on the conditionality that they would undertake that leg of the project. So I just thought I'll add that in, yeah. So we go back to Member Saga Singh Suklal.
Thank you very much, Chair. So I'll make this a little simpler, at least for the benefit of the listening public to understand, right? So I was on the point of FIDIC contracts. Of course, I would have done, it's no secret, I'm no engineer, I would have done my own research about FIDIC. And then, of course, being a lawyer, doing a lot of contracts as well in a previous incarnation, my understanding is that with respect to FIDIC contracts or contracts that are deemed, governed by FIDIC terms and conditions, a party to a contract should only, with good reason, amend the terms and conditions of a FIDIC contract, of FIDIC. Do you agree with me or no? Based on your experience in dealing with these types of contracts of this magnitude, contracts that are governed by the FIDIC Yellow Book, that a party to a contract should only, with good reason, amend the terms and conditions of FIDIC.
Party cannot.
Mr. Chairman, a party can't just extend, vary the terms. I mean, there have to be some sort of agreement. Now, as far as FIDIC is concerned, it does not, whether or not the employer got monies to pay for the work done through his own piggyback, borrowing it from somebody, it is immaterial. What FIDIC says is that, they recognize the fact that the contractor has to be paid. They outline how the payment should be made. When I say how the payment should be made, the timing, the windows and things. So after you have an IPC, you have been issued an IPC, there's a certain window by which the payment should be made. If the payment is not made because for some reason you don't have money, then there are penalties attached to that.
So FIDIC terms, so it governs more or less the terms, conditions, it governs best practice terms and conditions. It speaks to best practice as it relates to these types of contracts, correct?
That's correct.
So therefore, just off the cuff, would you be able to identify, for the benefit of the listening public, some of the major benefits you believe that exist in utilizing FIDIC terms and conditions as it relates to these contracts? What are some of the major benefits? And you see, it comes back to the mission of NIDCO to, of course, operate with the highest ethical standards, at the highest ethical standards. What do you believe, just to the benefit of the listening public who has no clue about, of course, FIDIC contracts, in your experience, Mr. George, dealing with these types of contracts, what do you believe is one or some of the major benefits of utilizing FIDIC terms and conditions to contracting parties and the contract itself?
Okay. Well, Mr. Chairman, I'll answer this way. When one uses FIDIC, one is using an internationally known, tried, and tested contract. And the effectiveness or value of a contract is a function of how well it has worked over the years, all the various case studies. I mean, FIDIC has been research used and case studies and things galore on FIDIC. So when one is using FIDIC contracts, one is at a good place.
Mm-hmm. It's a gold standard, the golden standard, you would say?
It's the best that we have.
The best that you...
in these parts. I mean, there are other types. Pardon me? Oh, well, yes, and I mean, it has lots of precedents in court of law and things. So it's a tried and tested contract. So we on in a good place to have used the FIDIC contract here.
And these contracts were modeled based on those that FIDIC guidelines, this contract.
Oh, yes, you have, Mr. Chairman, you have general condition and you have particular condition.
Right.
So, well, the general conditions are general. For example, it will tell you about the rules of the various parties to the contract.
Mm-hmm.
It will tell you about securities, what security you need to have. And then there'll be specific items that might be applicable to your specific contract that you can take now and form into particular conditions. So, it is well, it caters for the international best practice,
so
and
one
also
of the,
your specific.
So one of the things, for example, FIDIC provides for, speaks to, is the accepted standard, or the standard for advance payment terms. You'll agree with me. That's one of the standards established by the FIDIC handbook.
Mr. Chairman, the standard insofar as an advance payment should be made.
Correct.
It does not say what is the quantum. It is usual for an advance payment to be 10%.
Right.
But an advance payment could be anything the parties agree to.
Of course.
And of course, talking about advance payments, they are always secured with significant, well, not even bonds, yes, cash instruments like standby letter of credit.
So, of course, I agree in negotiating contractual terms, it's for the parties to decide. But certainly when it's state funds and the type of money that these contracts usually require or required to be paid, that's why we go back to the golden standard, which is what I was alluding to earlier about this whole FIDIC handbook, and it identifying the golden standard at which contracts of this nature. In other words, it provides the guidelines for states in negotiating these types of contracts, it provides general guidelines as to, even though, yes, I agree with you, parties ultimately decide what forms the terms and conditions. Because it's state entities, state money, you want to ensure as an entity and as a state organization that you align yourself with general and good practice. And you yourself would have admitted that the FIDIC itself sets a guideline, it sets guidelines, standards, that parties could then model their contract by. Now, I'm specifically now talking about the guidelines offered in this handbook as it relates to advance payments. And from my reading of the handbook, it's clear that one of the guidelines offered in this yellow book, this FIDIC yellow book, speaks to, or it identifies that advance payments for contracts of this nature should usually fall within a 10% of the contract sum. That's the guideline that is offered. That a 10% is the prescribed advance payment of contracts in this sum. That should be the advance payment that is given to a contractor in contracts of this magnitude. Are you familiar with those guidelines as established in the FIDIC Yellow Book?
Mr. Chairman, I'm comfortable. I am familiar. I have used them, and I have used them even as a guideline, and so that the payment is made, but going far, way above the 10%. And I'll give an example now, well, that's not an opinion, a practical example. I had to do a contract once as a contractor. I had tendered, and I was about to be awarded the contract. So the employer and his engineers and whatever, they came and they were making out a case that, okay, I have tendered, well, in those days, it was $13 million. I said, well, we can't make $13 million, but we can make 10. How about 10? I said, well, no, I mean, 30 million. I said, all right, I'll tell you what we'll do. What if I pay 75% upfront? And the argument was, if I were to now pay you 75%, I am giving you cash flow, and the cost of money to you doesn't exist anymore. So you don't have to mark up your price to me. So then you could probably do the thing for $10 million, even though I was asking for originally $13 million. Well, I didn't really accept it. And maybe, not because, maybe I didn't understand the benefits of that, so I didn't accept it. But I subsequently came to understand that paying me 75% upfront sounds good. But the securities I had to put up for that 75%, there's no way I could have gotten that, because as I told you, the securities that you put up for those payments, not like the contract performance bonds and so you could go by insurance company. It is a financial instrument, a letter of credit that you had to put up, and I couldn't put that up. So at the end of the day, I said, well, I know I tried, but I couldn't. So the point I'm making, it is not because one has paid, let's say, 15% upfront as an advance payment. One is being maybe reckless, or one does not take the best interest of the state and or the job at heart, right? There could be a reason why you need to pay that, but what you need to do is to protect the funds of the state. So I'm giving you the 15%, but you give me a letter of credit to cover it.
So I'm glad that you said...
Before you move on, Mr. George, but in relation to what the member was asking as well, would you take on board the consideration that the amount of advance payment is also linked to the procurement model, because she mentioned about 10%. Now, of course, 10% would be the standard for just construction services, most of the times. But when you come to design build contracts, 20% becomes the norm.
Well, there you go.
Yeah.
Yeah.
So it is also linked to the because in a design build contract, your initial cash requirements, because you have now a design element where you have to engage designers to get your designs moving, whilst you also have mobilization costs from a construction point of view. So which is it uncommon for design build contracts, most of the times, based on your experience, to carry a heavier advance payment, like in this case was 20%, as compared to the traditional just construction contracts of 10%? I mean,
Mr. Chairman, I'm hesitating because I don't want to be stamping or giving approval to the quantum. I will accept the member's point of view and to say, well, okay, the principle is what is important, the fact that it is paid. But sometimes, because of the how you call it thing, the security I have to put up, I might tell you, well, I don't want 10%, I want 5%. What if I tell you that?
No, I understand that. But what I'm saying is also in terms of the industry norms.
Well, yeah, but that's a good reason.
Design build contracts would normally carry a larger advance payment.
Yeah.
Yeah.
All right. Yes, I am being reminded here that whereas that can happen, it's not necessarily the case. So you see, so we're into an area that, I would still like to hold on to paying it as opposed to specifying how much should be paid. And what is suggested in the handbook that the member has read is not cast in stone. It is as a, the parties can vary that.
No, agreed.
To sort of suit whatever suit the parameters. Okay, so I will prefer, Mr. Chairman, to sort of hang my hat on that and to stay there.
Okay.
So in this particular contract, there was a departure from the 10% as prescribed by the FIDIC handbook to accepting 20% of the contract sum as advance payment. And, Chair would have indicated for design and build contracts, perhaps that may be a normal sum to accept. Based on the nature of the contract, that may very well be industry practice. But, you made mention about, once you're called upon to determine the type of advance payment that will be made to the contractor, critical, of course, are the levels and layers of protection that forms part of that negotiation or decision as it relates to what type of advance payment will be made. And that's where you drew reference to your own circumstances, sometimes based on the prerequisites, things that are required in order to get that type of advance payment. You may even drop your expectation from 10% to 5%. But based on this particular contract, based on my reading of everything that has been provided, I'm saying again and reiterating the point, there was a departure from the FIDIC standards of accepting 10%. There was two accepting that 20% advance payment of the contract sum would be paid to the contractors. Based on the evidence and information and everything that you would have met when you took chairmanship of the organization, can you say then, the 20% having been accepted, what due diligence, what systems were put into place? Because at the end of the day, this is public money that is being spent. And you made mention about the need to protect and to ensure, so yes, you may give 20, you may pay 20% of a contract sum, depending on the nature of a contract. You may pay 10%. You said the parties could agree as to what advance payment is accepted. I understand that. That's how negotiations go. That's how contracts are negotiated. But what due diligence, what checks and balances, based on all of the information and reports that would have been before you as chairman, what evidence is there to show that due diligence was indeed applied, and what requisitions were made from the contractors to provide NIDCO with in order for a decision to be taken that we will give you a 20% advance payment, that a 20% advance payment of the contract sum would be made on this contract?
Mr. Chairman, there were two levels. So when I joined NIDCO, there was in place a standby letter of credit protecting the advance payment that was made to the contractor. And for the public's
consumption.
For sort of knowledge, I will say that a standby letter of credit is a cash instrument. So this company is holding a quantum of cash here, which will be paid out after a certain condition is realized. So.
And the condition was, in this instance, would you? Mm-hmm.
If you have not repaid me my money, you don't get, I don't release your standby letter of credit.
And in fact, this is for the benefit of the public.
Let us suppose that I gave you that money upfront payment, and it was supposed to be amortized over a particular period. If that failed to happen, I can call in that standby letter of credit that I have, right? So I'm not losing anything because I have that cash instrument. So that's one level. Was due diligence conducted or carried out? Yes, due diligence was carried out. In fact, is it February of 20? Was it February? Let me just. Yes, February 2011. Yes, February 2011. So that is, and bearing in mind that the contract was awarded in July 2011. So we had February 2011, and even though what cabinet thing came later. All right, February 2011, the board at the time requested due diligence to be performed, and in fact 2 legal firms were used. Is it? There was a Brazilian company, and could I see? Right. One was Daniman, and the other was May and Company. So those 2 companies were used to perform due diligence on that OES company. So by the time they sort of came around to awarding the contract in July of 2011, due diligence had been performed on the company, and the people of the day, the powers of the day, felt that it was okay to sort of go on with the award of the company, award of the contract to the company.
So the due diligence reports for the members' information are in appendix, Mr. Haricharan. What appendix they are in? So
Chairman, the due diligence, the first report, May and Company, Appendix 9.1, and the second, Daniman, 9.2.
Okay. Yeah. And Mr. George, the thing with coming back to the question of the quantum of the advance payment at the bid stage, right?
At the bid stage.
In the bid documents, would it have been standard in this case that the level of advance payment would have been known, would have been stated at that time.
Yes.
Because as you rightly mentioned, in terms of the financial analysis of the bid that the contractor would undertake, the fact that they would have 20%
In hand.
cash flow in hand, it is going to influence their financial overheads on the project based on what borrowings they may have to do in order to maintain the level of cash flow of the project, and could also result in a better tender because their financial charges are reduced. So in this case, correct me if I'm wrong, at the bid stage, that information was made known that advance payment of 20% would be made.
Thank you for reminding me, Mr. Chairman. Yes, the quantum of advance payment to be made is usually always specified in the tender document. So it's not something that is negotiated at the negotiation. That is not on. So, yes, you're very correct, Mr. Chairman.
Mr. George, I'm looking at the amount of monies within the first 3 years of the project, and I'm also taking into consideration in your report in page 17, where it states that in the early stages of the project managers, AECOM, described OAS performance as slow and not up to contractual standard. By taking that into consideration, it would seem to me that the payments of over the first 3 years, or over the first year actually, the rapidity at which the amount of money went to the company directly from the Ministry of Finance and the Economy was far beyond what was being provided in service and in delivery of our expectation of OAS. Are you of that opinion?
Mr. Chairman, I want to just answer the member this way. That when we spoke about that schedule, that drawdown schedule, or not drawdown, but the payments that were made, the $1.something billion and so, those are not payments made to OAS, you know. Those are payments, those are monies made available to NIDCO. So NIDCO will get that money, and then NIDCO will take that money now and make payments under the various headings, so that they'll hold that money in their account, and when OAS send in, when they have IPCs, they will take from there and pay OAS. They'll have some sort of checks and balances, your checks and balance that will be monitored by the line ministry. Well, let me just quickly say that. So you have the money in your account, but before you can draw down from that, you must get the non-objection from the line ministry. So when you have an IPC, it goes to the line ministry and say, hey, I want your approval to take from there X dollars to pay for that, right? So then at every stage, the line ministry is kept apprised as to how you are using that money.
Yeah. So it's a good opportunity for NIDCO to earn a little interest on the side.
But not allowed to keep it.
Yeah.
Thank you, Mr. Chairman. I'll remember that and tell NIDCO.
Okay, yeah. So we come back to you.
Thank you, Chairman. Thank you, member. There are a few things I just want to, and I have to apologize. The truth is, Chairman, as we go through this, I find myself going back to the report, going back to some of the issues it is a colorful history, as you rightly put it. Chairman, I was a little concerned, and I wanted to find out. We have gone through the, and again, I like to continue my timeline, right? So OAS has been selected, negotiations have been conducted. There was a question asked by member Morris Julian, and I can't remember if it was answered. The negotiations were supposed to start on June 7th, 2010. However, negotiations never started until January 5th of the following year, 7 months later. Was there 2011? Was there any reason given for why NIDCO did not begin negotiations on the 7th of June as had been, I don't want to say approved, but decided?
I have not discovered, Mr. Chairman, anything in the record to suggest why. I can speculate that, okay, you had a change of government, new minister is coming in. I don't know, you need to take his fresh card or whatever. So all you need to do is to keep that bid active. So if the bid price is valid for 90 days, and you see that the 90 days are coming up, and you have not gone in and do the negotiation and finalize thing, you will write to the tenderer and ask them to extend the bid validity period to give yourself that breathing room. So I guess that would have been done, so that later on, when things were worked out in January of 2011, they could have started the negotiation with the person, with the tenderer. So I don't have a reason.
So, Chairman, I understand, and you've prefaced it by saying that it may be speculation. I find it strange that a conservative approach would have been taken at that point, but not on May 25th. So on May 25th, you rushed to tell the OAS that they had been speculated, but then all of a sudden you would want to be conservative in terms of when we start entering into negotiations. It is not meant to, it is just my own observation to match your observation. I find them to be conflicting in approaches. So, Chairman, there was a decision that was taken on February 10th. And that decision that was taken, I may be wrong, so you will correct me. A decision was taken to tell NIDCO, go look for funding for this project, right? Contract has been awarded. You can start looking for funding for the project. And then a subsequent decision was taken to fund it from cash flow. Yes? I'm not sure if it was answered. I have to apologize if it was. But can you give me a timeline for that? Just so I restore that in my own mind. When was the decision taken to move the funding for this project from an engagement of a financial institution to funding from cash flow?
Mr. Chairman, so there was the instruction given to, let's say, go look for funding. At the same time, a letter of intent was given to the contractor. And that letter of intent was given for a 90-day period to allow the financial arrangements to be put in place. On the expiration of that 90-day period, I think it went about 7 days late. When was it? When?
The contract was awarded.
Right, the contract was awarded there. When did the 90-day?
March 28th.
Oh, all right. The
LOI, the period started March 28, 2011. So if we had 90 days to that, by that time, funding should have been in place. I think just a few days later, the contract was awarded on, is it July? July 4, 2011. So the instruction was given to go find fund. A 90-day period was bought that you could use to find the fund. And just about the time when the 90-day period was to have come to an end, or it came to an end, and just a few days later on, money was, but you did not get that, the funding was not, you're not successful in getting the funding from the local banks or so that you had approached. But we have a board minute, a minute from the 59th meeting of the board, where it is reported that the board of directors was informed at its 59th meeting held on the 26th of May 2011 that the Minister of Finance had agreed to make available the sum of $1.5 billion TT dollars from Treasury deposit to finalize the contract with OAS. Okay, so you have an instruction to go find the funds. Well, presumably you're working on it, but you're not successful yet. And come the 26th of May 2011, the board of directors at the 59th meeting, they're reporting that they got word from the Minister of Finance that he's going to make available $1.5 billion from the Treasury deposits to finalize finalize the contract, with MOS. So the Minister of Finance was obviously aware of that window. So it didn't happen. He said, hey, I'm going to make available that money for you, to be available to you so that you can go finalize the contract.
So, Mr. Jordan, forgive me, because this is outside of my wheelhouse. My apologies, forgive me, this is outside of my wheelhouse, so if you just bear with me here. You are looking for financing for the project, right? That financing would be in the total agreed sum of the project. Yes, what was the final?
7 point.
7 point.
Sometimes 5.
7 point. Let's say 7.2, right. So you're in the process of finding that funding. That obviously is not going to be an overnight thing.
Correct.
So that process will take some time, yeah?
Mm-hmm.
In your experience, how long would a process like that take? And what would it entail?
Mr. Chairman, I'm being invited to speculate. You want me to talk about our very secured banks here? It'll take a long time.
Fair enough. But we agree that it would take some time, right? Now, during that time, you've also issued a letter of intent to OAS, right? And OAS will undertake work during that time, correct? Is that a usual arrangement? It seems to me that doesn't seem like a usual arrangement, but I may be wrong.
Mr. Chairman, the time between a letter of intent and the award of a contract is usually a bit quicker than that. But here you had the letter of intent being issued, and it didn't just say 90 days, it said any other period agreed by the party. So after 90 days, it could have rolled it over to another 90 or whatever it is. So I'm saying that, well, it was long, right? But it's two parties here. So if party A feels you need 90 days, and Party B feels that he has a very juicy contract that he has to stick around for, then he will oblige and give you the time required to get the funding, because he feels that he's onto something here that is beneficial to him.
But during that time, it's beneficial to them, yes. But if there's also an agreement to pay up to a maximum of $50 million US for any work being conducted in that time. At the start of a project, would there have been the possibility to do 50 million and 50 million US, correct? Would there have been the possibility in that 90 days to do 50 million US worth of work in that time frame?
Mr. Chairman, the 50 million US dollars was a cap. They were saying, I'm going to make, $50 million is going to cap, is what you're going to be paid from. So you go ahead and do whatever preparatory work, and you could start to mobilize, you could even bring on your designer and start doing your design and things like that. You get that going. And we will pay you for those services from that $50 million. If, however, at the end of the agreed period, whether it is 90 days or an extended period beyond the 90 days, if at the end of that period I cannot put my finances together, I am going to pay you $50 million for any claims that you were to make against me. You might say, well, I did $55 million work, and lo and behold, we cannot go forward. I still have to pay $50 million. Or you might say, well, if you did less, you're still entitled to $50 million because I gave you the expectation that there'll be a contract after the period, and it has not happened. So, so the $50 million was a cap. That should have been, I don't want to, that should have been recovered. Whatever was expended from the $50 million was supposed to be recovered when the contract was awarded and the real advance payment of the 20% was about to be made. Was to be made.
And that was not done.
That was not done.
If you allow me as well, is there, other than the instruction, and from the way you've described it, I don't know that it is a written instruction, other than the instruction to the board at NIDCO that the Minister of Finance at that time was going to make $1.5 billion available to them from Treasury bonds? Is that it? Or from the Treasury? From Treasury deposits. So cash flow, right? Was that a written instruction, or is it that there is a letter that shows that, or is that just noted somewhere in the minutes that this was the position taken?
Mr. George, previously you did mention about it being reported at a board meeting. Yeah.
Yeah.
Yes, Mr. Chairman. So that's where I'm going now. So it was at a board meeting. It was reported. So that's where I'm getting my evidence from. It was reported there. I think that's gospel. And more than that, for more evidence, reported there on the 26th of May, and the actual payment, the check of $1.5 billion was paid on, 1 month afterwards. Right? So I'm saying that's where I get my evidence from.
Right.
Right? And the board would not lead me wide. So I'm going to go with that.
No, that would have been evidence of $1.5 billion having been given to NIDCO in order to pay this. But of course, the contract was not $1.5 billion. So was there an instruction to cease looking for financing, and we will pay this going forward from I keep saying from cash flow.
Mr. Chairman, we have not discovered any such instruction. I can only speak from the evidence of what happened. You know, that these balloon payments or these tranches was just
kept coming.
Just kept coming, yeah.
So we are seeing evidence of the money coming to NIDCO. We have no instruction anywhere that you can go back to substantiate the decision taken by the board. So that decision should have come from some manner of instruction. And NIDCO stopped approaching any financial institutions for funding. Can I ask, up to the point that they had received the first 1.5, had they approached financial institutions, whether those be local or foreign and what institutions those would have been?
Mr. Chairman, I see here on page 16 of 36 where we reported that NIDCO issued tenders on the 24th of February 2011 to 13 financial institutions, and their institutions are listed there, right, where they went out and asked for expressions of interest or whatever. But they did go to 13 financial things. At the close of the tender, they got responses or proposals from nine of those financial institutions.
Local and foreign, or all local? Or all foreign?
Local and local and foreign. Society, Deutsche Bank, Citibank is also Answer Merkel, Carlot Capital Group. All those here are local. Yeah. So it's a combination of both. Yeah.
And they just simply never went beyond that stage. So they would have gotten submissions, and it just never went anywhere from there. And we just funded this thing going forward from cash flow.
Mr. Chairman, that's my read of the situation.
I think, Chairman, before Member Ibrahim, you okay? Yeah, is that, I mean, you did mention about the LOI or letter of intent that was issued by NIDCO on the March 4th, I think, of 2011. Yeah. But on the same date itself, there was a conditional letter of award on the very same day that was issued by NIDCO to OAS. So we have two pieces of documentation. One is a letter of intent, and then one is termed a conditional letter of award. Now, according to the FIDIC conditions of contract, the yellow book, I think section 1.1.4, or it could be 1.1.3, make provisions for a letter of acceptance. Yeah, letter of acceptance, that's the term, according to the 1999 Yellow Book edition, because there's a 2017, I'm not sure what that has. But that 1.1.3 or 4, it was not used in the particular conditions that came out of the general conditions, right? So it was not used. But the terms letter of intent and the terms conditional letter of award in the, for my review of the particular conditions of contract, the interpretation of those terms are not in the contract, are not in the particular conditions of contract. And so we have two items, the letter of intent and then the conditional letter of award, that is not, it is not there in the particular conditions under the section on interpretation. So, you know, these instruments were delivered to OAS. But there seems to be a gap in terms of it being linked to the particular conditions of contract, because it's not mentioned. That's one. And the second thing is that I mean, we're talking about the payments and all those things. And we have to, again, correct me if I'm wrong, the advance payment, the letter of intent was based on a cap of $50 million. But from my reading of the documentation, an advance payment of $7.5 million on the LOI amount was made. And also, it came out of the 20% advance payment for the overall contract. And that advance payment, 20%, or correct me if I'm wrong, was actually paid on March 28th. So here we had a situation where a letter of intent is generated. Funding is provided, there's a cap. An advance payment of $7.5 million was paid on that letter of intent. And then we have the substantive advance payment being made on the 20th of March. And the contract was signed on July 4th of 2011. Is it normal practice that an advance payment is given so much ahead of the actual signing of the contract? Because my limited knowledge would tell me that on the award of the contract, on the signing of the contract, then the advance payment is made.
Chair, the figure I believe wasn't 7.5 million, but 37 million.
Yeah, well, 37 plus 7.5.
Yes, 37
What is termed in the interim payment certificates is an advance payment 1, which is 7.5 million US, and then there's an advance payment 2, which would bring it overall to the 20%. But, I mean, payment made on March 28th, contract signed on June 11th. So the contractor actually had this money in hand. And yet still, the contractor is being paid money through a letter of intent, through the 50 million US facility. How do we reconcile that?
Mr. Chairman, and if I might borrow a word from one of the members, that's a convoluted section of the contract that I don't understand. And I tell you what I don't understand. That $50 million is the cap, yes. All right, so we're looking at the letter of intent and what was the other one called? Letter of award, right? Conditional letter of award. I will take the chairman's advice on board and I'll just check it and see. But I will, if I were to give to indicate, well, where the conditional letter of award appears to be talking to what the contract is required. But I take your word and I will check it and see whether that is so. That conditional letter of award did make reference to the letter of intent. So the letter of intent is the no, that isn't bad light to use that word. But let's say letter was the outside instrument, right? So letter of intent is there, and yes, the letter of intent, the money, the payments you made.
Mr. George, you said it was the outside.
Well, yes, yeah. It's extra contract, you
right.
know.
But
so,
could we say that it was not contractual at that time?
Well, yeah, that might be a better word. Okay. Yeah. It was not as per the FIDIC contract.
Yeah.
Right. It is something that the parties agreed to. Right. So that was the letter of intent. And the fact that payments, there's a promise of payments to that contractor without any security. Payments that you're making there would have been exposed because you have nothing holding to protect you. So from that point of view,
I have a problem with that. But more than that, the FIDIC engineer, I think there were about 3 or 4 payments made. Was it two payments made under that $50 million, coming up to, I think, 30-something million? Well, that's it. Right. $36 million. But here is the convoluted part. When that IPC 1 for the first payment under the LOI was being made, when you look at the schedule that was drawn up, there was a $50 million, the cap, and added to that was $7.5 million. And that $7.5 million was described as VAT. VAT is never paid on advance payment. It is removed from the reckoning, VAT, provisional sum,
and then prorated.
day works, and there's another one, and contingency. All those things are backed out from the bid price, and the raw work component, cost of work component, that is what the advance payment is paid on. So strange, it was a strange thing to see them adding $7.5 million to the $50 million. And so, all right, fast forward now, contract is awarded. And when a contract is awarded and executed, the contractor submits, or is made to submit, according to the FIDIC thing, the security for the advance payment. So I think the advance payment that should have been made over the total sum was $135 million US. So one would expect the contractor to present you with the standby letter of credit to cover that, and then you'll make the payment to him. It is said that the payments under the LOI, that was one of the conditions. That payment had to be backed out from the advance payment of $435 million. But it was not done. And what was done instead? $7.5 million that they, illegally or added to the $50 million. That was taken out. So I don't understand how they could have remembered to take out the 7.5 and they didn't remember to take out the other part that was paid to the contractor at that time. Right? So I don't understand how they didn't take out the 36 when the LOI did say that is the time when you must claw back and get back your money. They allow that to go, and they take out 7.5. So when I talk about the thing being convoluted, the thing makes absolutely no sense to me, and I wish somebody could explain it.
No, but let me come back to the interim payment certificates, right? Because it is on that basis that payments are being made to OAS, right? Now, interim payment certificate 1, from my recollection of what I looked at, was dealt with what was called the advance payment 2, right? Which was the difference of the 20% minus the 7.5. And in that interim payment certificate 1, the 7.5 million US is termed as advance payment 1. But Mr. Haricharan could correct me if I'm wrong, but I've not come across an interim payment certificate for the 7.5 based on what was submitted by NIDCO. So was it that the 7.5 million US dollars was paid to OAS without the AECOM, without any AECOM interim payment certificate? Because there's no, from what we have seen is there's no IPC for the 7.5. Attempts were made to account for it in IPC 1.
Chairman, your recollection is correct. Our records doesn't show certification for that 7.5, and yes, it was reflected in the first IPC number 1. That's correct.
Okay. Do we have any idea of the date for that payment of the 7.5? That was paid by NIDCO to OAS.
Mr. Chairman, I'm being reminded here that that 7.5 would have been paid on March 28 when the official start, at the official start of the LOI. But, Mr. Chairman, I'll ask for crave your indulgence a bit. This is something that we have to better understand. As I said, I am totally confused. And, this thing makes no sense. And the thing about it is, as you were alluding to, Mr. Chairman, those things are not just paid by somebody, some absent-minded person. There's a system. So if AECOM were to do something and it is not in keeping with the norms and policies that you're supposed to follow, I would expect NIDCO to sort of flag it and ask for it to be corrected. But when you have both persons doing the same wrong thing and having it so convoluted, because I tried in all way and fashion to make sense of what the record was showing me, and I have not been able to do that yet. So I will ask Mr. Chairman to just allow me some more time to see whether we can make sense of the payments that were made under the LOI, 1, and 2, why wasn't it deducted when the real 20% payment was made? Because they remembered to take out $7.5 million. That's why it went from 135 to 128 something, right? So what about the others? Right? So.
No, but in the interim payments, it is subsequent to IPC 1. When, because the other 2 payments that were made under the LOI, there were 2 other payments.
2 payments, yeah.
For
$36 million.
For works executed. And those were subject to interim payment certificates from AECOM. So here we have AECOM preparing the interim payment certificates, but are you aware whether they were instructed that deductions had to be made under the based on the LY in those subsequent interim payments?
That is not, Mr. Chairman, clear in the records.
Yeah.
Yeah, but I would say that he ought to have been aware, because he is the one that when I say he, AECOM, the cap was placed, and that those interim certificates were, that is the interim certificates under the LOI payments, those were computed based on items of works done. Those items of work were part of a work breakdown structure, WBS, that AECOM worked out with the contractor, right? So under LOI, these are some of the works. Well, even that is really confusing to me, because there was a line item of thing under that spoke to schemes and bonds. One that said even landscaping. So I said, but what is happening here? But anyhow, those line items were there, and sums amounts were placed against them, right? And they used that as, they'll have us believe that was the objective way of doing it. So when the contractor comes in with requiring a payment under the LOI, he has a basis on which to make his claim, right? So I saw that, and even that was sort of not clear, because the items I will expect you to have there will be items that speak to maybe the designs, maybe the mobilization, maybe, I don't know, you have to bring equipment from Brazil or wherever, that kind of a thing. But what I was seeing there did not look as a WBS that you will have at the start of the job to spend that, spend from the $50 million.
If I may ask a further question in that, seeing that the full amount of the advance payment was satisfied by March 28, right? What advantage? The advance payment was made? Yeah. March 28? Yeah. In that context, what advantage would the LOI have brought? Because if the intention of the LOI was to accelerate the startup of the project, get the contractor moving, let him mobilize, get his design work moving, right? And you are paying monies based on that, right? And then after the letter of intent on March 4th, by March 28th, the fellow get all his advance payment. Am I interpreting it correctly?
Mr. Chairman, if I might just clarify this, not clarify, but correct here. He did not get all his payment on March 28th. March 28th was the starting date for the LOI activities. And on that day, I'm being told that he got $7.5 million.
All right, but the rest of the...
Came after.
What did?
LOI 1 and LOI, IPC 1 under LOI and IPC 2 under LOI. So we have here for LOI 1, IPC 1 under LOI payment, 17.8 million, and for IPC 2, 19.11 million, giving you a total of 36.9 million. So then he would have gotten what, 36.9 plus 7.5?
Plus 7.5.
They reduce these figures by the advance. These were reduced by the 7. In arriving at 70, they had a higher price, deducted the advance. In this first one, they deducted 5 million, correct?
Yeah, so I think in your response, the figures you give are not the net, it's a gross certified. And the actual net would have been taking into account the deductions.
Right. This was paid, but in paid to this was the gross paid to OS. But in AECOM arriving at 17, they will have started with a higher figure that they say that OS would have worked for, and minus that 7.5 that nobody knows is paid.
Right. So it will be the gross you have there, and then you have to take out the deductions.
Right. So this is the net of what.
Well, my question is, when was the
7.5
advance payment, not the 7.5, the difference?
That's later on, after contract.
After contract. Do you have a date?
Yeah, after contract. Yeah.
Do you have a date for that?
I'm looking at the records, and it's sitting somewhere back in September of 2011.
September?
Okay.
Yeah.
Somewhere forwarded September 2011.
Let me see if I can find it here.
So, Mr. Chairman, here's why this thing is so confusing to me. If the LOI, the IPC 1, if the IPC 1 and 2 under the LOI took back the $7.5 million that was paid, let's say, before those IPCs. So you paid the 7.5 and you took it back under those IPCs. How it is down the road now in, say, September, when you come now to make the 20%, you know, and that could be due to the fact that the contractor is just submitted his securities. Yeah. So it's quite possible. So now you're paying the 20%. Why are you deducting 7.5? Why are you going from 135 to 128? So the thing is just getting curiouser and curiouser. As I said, Mr. Chairman, and I crave your indulgence, I will need to sort of look at that some more because it just doesn't make sense.
No, Mr. George, I'm in the same boat with you. I think members of the committee as well, we are a little confused about the whole LOI, the introduction of the LOI, the objectives of the LOI, and whose decision was it to introduce this instrument into the contract? Are you aware of how that decision was made? Because the negotiation report has nothing about an LOI, has nothing about a cap $50 million US payment. That was never addressed in the negotiations. So are you aware of any of the genesis of this?
It was a tenders committee decision.
How did it come about?
Yeah. The brief research that we've done so far suggests that it was first mentioned at the tenders committee. I don't have the data here right now. It was first discussed at the tenders committee and then ratified by a board decision. But we can get that documentation for you because I have seen it.
When you say tenders committee, this is
NIDCO's tenders committee.
NIDCO's tenders committee.
At that point in time, and NIDCO board would have agreed to that way forward.
Okay.
Would you also be able to provide us with who was the persons who sat on that tenders committee? Because it's usually a board member together with other administrative members. So if you can also provide that, that would be very useful. And just for the record, the Minister of Finance at the time was who?
NIDCO.
And the Minister of Works and Transport at the time was who?
I can't say that. I'll have to check.
It's 20 minutes past 3. We wanted to wrap up at 3:30. And then we would have to allow in that the remaining 9 minutes would be for closing remarks by Mr. George and closing remarks by Mr. Mohan Singh. You would give the closing remarks on behalf of Ministry of Works and Transport. Just briefly, yeah. So we probably would probably just have one more question before we close off. Yeah. So yeah. So any member, if we
Just that I find
we could close.
It was just the last question that I asked. I mean, NIDCO has so much information there's so much information before the entity that we could have had 3 sets of submissions and simple question, who's the Minister of Finance at the time, who's the Minister of Works and Transport, and that information is not forthcoming. That was just my final question as we close off. I know we would have another opportunity to interrogate the entity. Thanks, Chair.
Mr. Chairman, I am taken by surprise here. Am I supposed to be able to answer those general knowledge questions, Mr. Chairman? In future, then I'll prepare. I was not aware, but I'll prepare.
Yeah.
But I mean, how can that be placed?
Mr. George, you also have a team. You have a team with you, and I think probably the member was hoping that within your team you may be able to provide that information. But of course, it can always be provided next time you are here.
I'll do that, Mr.
Yeah. Yeah. So let's close up. I think we have accomplished a lot today. So any closing remarks? First, we'll go with Mr. Mohan Singh, and then after we'll go with Mr. George.
Thank you, Chair. Good afternoon again, Chairman, members. On behalf of the Permanent Secretary and the wider Ministry of Works and Transport team, we thank you for this opportunity to appear this afternoon and present information. It is our understanding that it is the first of a few sessions to come, and we remain available to provide information as required by the committee. I thank you.
Okay, thank you very much, Mr. Mohan Singh. Mr. George?
Mr. Chairman, I thank you and the honorable members for giving us this opportunity to appear before you and to share the information that we have in our record in an accurate manner. We did enjoy the exchange and so today, and we want to give our commitment to continue to work with the committee and to provide whatever additional information that either we have promised to or additional information that you will be asking us to provide. We will continue to work towards doing that, asking questions, going back into the records, and trying to get answers to some of the questions that we did not have today as far as the project is concerned. So we thank you.
Okay, thank you, Mr. George. And, you know, one thing I would like to mention is that, I mean, the success of this inquiry, it depends on the stakeholders who come before us. And I think based on the response to the questions, that the preparation, particularly in terms of NIDCO, I think we do know it's a tremendous exercise. A lot of work. It would have taken a tremendous amount of work to put together all the voluminous appendices and generally try to answer all the questions that were asked by the committee. So on behalf of the committee, I would like to extend our appreciation for your inputs thus far, for the sessions today, your inputs and your cooperation, to all officials who are here today. Some of you would not have said anything much, but I'm sure in the input of the responses, you would have had major inputs. So thank you to all officials. I would like to thank the viewing and listening audience on television and our YouTube channel. I'd like to thank all committee members for their attendance and active participation, to thank the broadcasting team of the Parliament, and of course, last but not least of all, our secretary, our secretariat, through whose work sustains the work of this Joint Select Committee. So we'd like to thank all members of our secretariat. So at this point, I would suspend this meeting. Thank everybody again, and I would invite members of the committee, if you could please stay back for a short while afterwards. So thank you very much.